Welcome to Looking at Legal Stuff. Today we have 19 hearings, including 2 new updates, with a high conflict couple where dad tries to demand a default parenting plan be entered when mom misses a single hearing, and he also thinks mom should be held in contempt for not paying him child support, despite there not being any order to do so. And that's just for starters. Dad becomes increasingly hostile towards mom, her lawyers, and especially the guardian ad litem. He makes one accusation after another, and he fights Mum every step of the way as she tries to reestablish her visitation. So what does Mum have to say about all of this? Let's find out.
Cameron Miller and Taylor Young. I see a Taylor and I see Mr. Miller. All right, good morning.
Good morning.
Ms. Taylor, were you asking for a continuance earlier?
Yes, I didn't
receive. Ms. Young, I guess. I'm sorry.
Yes, I haven't received the paperwork itself, and so I don't know exactly what I'm going against. And I also would like to get an attorney because this has been going on for far too long. And my dad just passed away, and so I've been dealing with that this week, and I did not have time because I just got the little piece of paper in my mail the day before yesterday. And so I got to go to USPS and get the paperwork, I guess. All I got was the thing, but I didn't know that until I checked my mail.
Mr. Miller?
Can you hear me, Your Honor?
I can, yes.
Okay, so I want to put it on record that Miss Young's packet actually was delivered on February 25th at her mother's house. Her grandfather signed for it. And we're here because she hasn't been paying child support, and she wanted to take it upon herself and to collect the taxes on a child that she has not been providing for over a year. So
and Your Honor,
I'm not finished.
We're not going to talk at the same time. Mr. Miller's turn. Go ahead, Mr. Miller.
In that I called all the right people, meaning the IRS and all that, and they're doing an investigation on it because now it's tax fraud, because I have full custody of the daughter. Okay. I have full custody of her. The daughter lives with me. She goes, if you got something to say, Taylor, let's say it, because I'm not done.
So I can speak.
Just a minute. We're not going to talk to each other. Okay. You direct everything to me. And the question right now is whether I should put this over a week or two.
I would ask not to, because she has been properly served.
No, I haven't. I don't my mother.
Just
oh my gosh.
Let Mr. Miller finish, okay? And Ms. Young, if you speak out of turn again, I'm going to mute you. Okay.
She does. I have the paperwork of her grandfather signing for it. I turned that into the courts and all of that.
Okay, let me tell you, I'm going to accept it was served on February 25th. That still is not enough time for someone to respond. That's, I think, only 5 days, and that isn't enough for someone to respond. So based on that, on just that alone, I think a continuance is warranted. And you're bringing a motion for contempt. Really, nothing's going to change between now and a week from now or 2 weeks from now. So, Ms. Young, how long do you want to put this out?
I have a meeting with the cremator on Monday, but I'm meeting with an attorney next week. Okay. I talked to them already, and they're going to represent me because we've been doing this too long. And
okay, let's then go out 2 weeks to March 16th.
Okay.
And this is usually Commissioner Cotterell's docket, but if I happen to be on this docket in 2 weeks, I will expect everybody to be ready to go forward at that time. Okay.
Thank you so much.
All right. Thank you, Mr. Miller.
Okay, thank you, Your Honor. Have a good day.
Yep. Next is Cameron Miller and Taylor Young. I see Mr. Miller's here.
I'm here, Your Honor.
Diane Lefker, limited license legal technician with Ms. Young, Your Honor.
Okay, thank you. I need to bring up two things. First of all, Mr. Miller had submitted a motion for default in this case that I've got several days ago. He did that ex parte. I didn't sign it because Ms. Young has been participating in the case. And when she appears, she, first of all, is entitled to notice of that. But I think her failure to file a formal response is at this point an oversight. She clearly wants to be involved in this case. So I'm going to set this out to March 30th, not the whole case today, but just the default portion of it. I'm going to set out to March 30th for Ms. Young to file a response. And if one is not filed by then I may enter a default, but I'm not going to do that today.
Yes, Your Honor, we'll get one filed right away.
Okay. What we're here about today is a motion for contempt that Mr. Miller has brought. And so, Mr. Miller, I'm going to ask you to argue that case first. You'll be the first one, and then Ms. Young, you'll have a chance to respond. And then Mr. Miller, you'll have a chance to respond to Ms. Young, and then I'll make a decision on that. Okay. So tell me why you feel a motion or an order of contempt should be.
Because Ms. Young has obligations to her daughter and she's not fulfilling them at all. She's had multiple opportunities to reach out to help with everything, and she hasn't done that. Taylor's about Taylor. Taylor doesn't care about her daughter or fulfilling needs for her daughter or trying to help her daughter. Taylor doesn't even have a job, for one, so she really can't support herself or her daughter. And, you know, I've been supporting Malaya now for over 2.5 years, okay? And she's been living with me. And I also want to put on the record that that packet that Miss Young turned in, completely false. For one, she doesn't state, and the sad thing is that she has an attorney that's helping her. The attorney can't be that smart because she doesn't ask the simple questions of the facts of, oh, me and Miss Young were together. No, me and Miss Young haven't been together for over 7 years. For all you know, Your Honor, you know, we just got done last week in a relationship. False, okay? The other thing is with child support contacting her, Miss Young says that they haven't. False. I just got a letter in the mail yesterday stating that they're asking me how to get a hold of Miss Young. How do we find Miss Young? Because Taylor does not respond. Miss Young does not go in to the post office and collects her packets that, you know, I turn into the courts. I send to her mother's house. I send to Miss Young's house. I have officers try to serve Miss Young. Taylor does not care. And quite frankly, I'm done. If she wants to go play around with some lawyers, well, I'll go get a big time lawyer too, and it will be done. Because I'm not about it for me no more. It was never about me. Like, Taylor is about her. This is about my daughter and what my daughter needs and what my daughter deserves. My daughter doesn't deserve somebody who does not care about her well-being or care about her needs or cares about her financial areas or where she's living or what, you know. I'm done. I'm ready to get it done and move on. That's all I got to say.
What are you asking the court to do?
Hold her in contempt because she has not done what she is supposed to be doing.
And what I understand from your motion, you've indicated she hasn't provided school clothes. Is that right?
Correct.
All right. She quit her job.
Correct.
She did not follow the parenting plan by administering the medication.
Correct.
Okay. You indicated on 6 occasions that you've determined she did not give the medication to Malaya?
Malaya.
Malaya. Okay. Okay. Thank you. Ms. Young, would you like to respond?
Yes. Actually, Your Honor, I do have a job. When he went for child support, I was a jack in the box and I got a new job. He just didn't know that. I am fully employed. I have lived in my apartment for a year now, and I do take care of Malaya. The problem is I'd send her with clothes and stuff and they wouldn't be returned. So I would constantly be buying her new stuff. I asked for them to return her stuff and they refused to. So I stopped sending her home with clothes because they weren't being gave back to me. And so I said, okay, then when she's with you, you have her clothes. When she's with me, I have her clothes. I've never kept anything from her. I've never not taken care of her. Cameron keeps her from me. All these things he's saying he's doing. I want to be in my daughter's life 100%. He refuses to let me. And he hasn't always provided the medication. I have text messages of us trying to get her meds and he refused to give them to me. I already didn't feel comfortable with him. So we went for my grandfather, my mother, my uncle. We were all willing to get the medication and he refused. And then they just didn't respond. Then there's also much where Samantha said that it's okay for her to not have them for 2 days. She'll be fine over the weekend when they forgot the meds. So now I'm under the impression, so it's okay for them to forget meds. But when I did not give them to her one time because she was having a mental breakdown. And I told him that. I was like, she told me that they forced them down her throat. I wasn't going to do that. So I didn't give them to her that morning. Correct. But other than that, I do give them to her. We talk to my stepmom on the phone. She helps us. She hates them, but she definitely takes her medication. It's true I don't agree with it, but she does take her medication. And he hasn't had her the last 2.5 years.
Are you willing to follow doctor's orders on the medication?
Yes.
Okay. Mr. Miller, any response to?
Yeah. Oh, yeah, I got a response. Okay, so that medicine that she's just now talking about, where they tried to contact us to meet up with us, she's lying, okay, under oath again, because when I originally put all of this paperwork in, that's when Taylor kept my daughter from me for 3 weeks. 3 weeks. That's at the beginning of all of this, Your Honor. That's in black and white paper. Because that's where the restraining order came into play. That's how I got the restraining order on Taylor and with Malaya because of child neglect. Okay. That's how that happened. And I don't keep my daughter from Miss Young. When we first broke up in 2016 or 15, when Malaya was 3, Taylor was the first one to play that keep away game. I don't play the keep away game. Okay. And Malaya has lived with me for 2.5 to 3 years. I've already been in Cowlitz County for 2 years. I've lived with Malaya at my girlfriend's house, at her father's house in Napavine, Lewis County for a year with my daughter. That's 3 years running, going on 3.5 now. Okay. Malaya has gone to school down in Cowlitz County for 2 years. My timelines are adding up. Miss Young is completely wrong. Okay. Her attorney is not asking her the right questions. It doesn't seem like. The other thing is, what else was it? What else did she say?
Does Miss Young see Malaya now?
Every other weekend, because you guys, as your courts, ordered that. There was the other judge, the other male judge who was doing our case. That's why he offered every other weekend, is because he felt as though Taylor was putting Malaya in harm's way. He granted my no contact order. He granted everything because I came with the right documents. I'm doing what I'm supposed to be doing. And quite frankly, on docket, I'm not lying. Miss Young, under oath, is lying to the judge and to her lawyer. Flat out about it. And Miss Young knows she's lying. That's the sad part. Because if I was lying, I wouldn't have a solid case. I wouldn't have a solid case at all. And I'm pretty confident that my case is solid.
Okay. The other judicial officer was Commissioner Cotterell, who
yes, Your Honor,
those orders. All right, I've looked at the file and at the motion. Mr. Miller has brought a contempt motion indicating that Ms. Young has not provided school clothes, that when she was—
that's what it was.
To support Malaya, she quit her job. She hasn't followed the parenting plan, and a particular concern is that she has not given the ADHD medication. And as she indicated here, she doesn't agree with that, but she disputes whether the indication that she did not give it. I'm going to deny the motion at this point, and the reason is I did not see a child support order in the case, that there's no specific order relating to medication. She's given, I think, joint authority over healthcare issues, but to read that to mean that she absolutely has to give certain medications, I think that would be overly broad at this point. There's no tax exemption order, and there's nothing in the temporary restraining order about contact through third parties, which was another issue. So the reason I'm denying it is I don't think there's any orders that require what Mr. Miller says should have been happening. I do think Mr. Miller's order does raise issues that should be clarified going forward, okay? So I'm going to do that so that everybody is on the same page at this point. So first of all, if a physician has ordered medication, whether it be ADHD or any medication, then Malaya is to be given that medication, whether she's with the father or the mother, okay? And if from this point on, there's evidence that Ms. Young is not providing that medication, then that would subject her to a contempt order, okay? I'm gonna allow, this was not clear, but I'm gonna allow contact through third parties between the parties. I think a lot of times I will indicate that a protection order or restraining order prevents somebody from contacting the other party directly or indirectly. So that would include third parties. But here there needs to be some way to communicate regarding the transfer of the child and other issues. So I'm going to allow contact through third party. And finally, there were issues, comments made about disparaging remarks made to the child regarding the other parent. I'm going to prohibit that being done in front of the child. That the parties, the parents cannot for lack of a better term, badmouth each other in front of the child going forward. Okay. So those are the three things I'm going to put in place today. I'll do a bench order to that effect.
Commissioner, can I add one thing, please? Can you, with the medication that's a controlled substance, such as the ADHD medication, that father is required to
I'm not required to give you guys that information. No, I am not.
Let her finish. Okay, Ms. Lepker, go ahead.
Thank you. That he is required to provide that medication for mother's visits, and if he doesn't, then he needs to make arrangements to get it to her in order for her to give the medication.
Okay, so I do send my daughter with medication. You should probably ask your person right there that when she decided to take my daughter out of her home 3 weeks prior to school. You must not be that good of an attorney.
Okay, so
I need to go. I need to go, please.
I'm going to add that if you expect, if the doctor has ordered medication and it needs to be administered during Ms. Young's visitation, that will be provided to her.
It is provided with my daughter to Malaya every other week, and my daughter goes there.
I'm not deciding that or even disputing that. I'm just saying that's going to be part of the requirement going forward.
Okay, and I want to put on record that I am not required to give the name of the medication to her mother. I'm not required to do that, and I'm not required to let Taylor go to Malaya's doctor's appointments. I'm not required.
I don't know if that's true. What I believe I saw
the restraining order. How is she supposed to go with the restraining order? That don't work.
Well, that may prevent it, but I think the parenting plan does not prevent that.
No, you're right.
Okay. All right. So I'm going to enter these orders as we've discussed.
I got one more question.
Go ahead.
Where's her attorney practice at?
Her attorney is what's called a limited license officer who, you can look it up. Ms. Lepker, do you want to disclose where you practice?
I have. He's already received my documents, but I practice with the law firm of Andrews, Terry, and Jeffers in Vancouver. And I'm happy to send you over
I already got it.
Okay, thank you.
Okay. All right. I think that's it for today. Thank you, everyone.
Thank you, Your Honor.
All right, let's call the Cameron Miller and Taylor Young matter. This is cause number 22-3-36908. See, Cameron Miller's on the line. Can you hear me, Mr. Miller?
Yes, Your Honor.
Okay, great. I can see you. And then I'll ask if Taylor Young is on the line. Taylor Young, are you on the line today? All right, Ms. Young, I'm not hearing you. If you are on the line, please unmute and state your name, please. Taylor Young. Okay, so I'm not hearing any response from Ms. Young. So it looks like, Mr. Miller, you filed, looks like several motions. One is a motion for a default. Second is a motion to amend a parenting plan. Third is a motion to amend a restraining order. And one thing I need to double check is the service. You've heard me talk a lot this morning about service. So let me just take a quick look at the file, make sure we're good there. Okay.
Hey, I'm almost done. We're on me right now.
Okay, so it looks like your motion, Mr. Miller, I'm seeing your motion for default was entered. Looks like you filed it back in September of 2022. Does that sound about right?
Correct.
Okay, and we had a hearing in September. There was some concern about service issues. Okay, I've got my notes here, so let me take a quick look at this. So looks like Ms. Young was served that motion for default, or she was served on the 26th of August of last year and also served on September 6th. Judge Basher found that 90 days had not transpired because it was serviced by mail. So at that time, Judge Basher denied the default order because it needed to be a longer period of time. Then on September 22nd, both Mr. Miller and Ms. Young were present, and the judge entered a parenting plan at that time. And the mother has not filed a formative response or a formal response. And it looks like it was previously denied. And so we're back on. So was there so what I'm seeing, Mr. Miller, and I apologize for kind of talking out loud, is that there was that September motion for default that you filed. It was heard by Judge Basher. He denied it because the service time periods are longer when it's mailed, and the 90 days had not yet transpired. So he denied the motion for default. And so is there a new motion for default that's on the table?
I believe so.
Okay, great. So the clerk just looked at me and gave me that look and said, look in your paperwork. So I'm looking in my paperwork now. So thanks for your patience, Mr. Miller. I do see it here, so let me take a look at this. All right, so here's the new motion for default. I've got it. Thank you. So I did look at this earlier, so let me review it again. All right, there we go. All right, so the motion for default basically indicates that you're making a motion to the court because you filed and served the other party on September 22nd with a summons and a petition. And that was at least 91 days ago, kind of what we were talking about.
Right.
And that you live here and she lives in Thurston County and the kids live here, or child lives here, and that she's not covered by the Service Members Civil Relief Act. Okay. And then did you give her a copy of, did you give her a copy or send her a copy of this motion for default?
Yeah, I believe we did it through email.
Through email? Okay.
Yeah.
All right. Let's take a look here. Mailing, okay. Bear with me one quick second.
Yep.
Let me ask you a quick question, Mr. Miller. It looks like you filed a notice of a hearing for April 13th, this coming in a couple of weeks. What's the purpose of that? Is that the motion to modify the parenting plan or amend the restraining order?
I believe so.
Okay. So
a lot of this is just happening so fast, and I'm trying to juggle this and juggle work all at the same time.
Yeah, it's
tough. My girlfriend, yeah. So I believe we're all on the same track.
Okay. So today we're March 30th, and then I see this notice of a hearing that says, hey, we've got a hearing scheduled on April 13th to talk about a motion to modify the temporary parenting plan and the amended restraining order, which I guess kind of makes sense because today you're asking for a motion for default to have the parenting plan and everything ruled with what you asked for because there hasn't been a formal response.
Correct.
And then we're coming back in 2 weeks to modify that parenting plan that we just entered today potentially and modify the restraint order. That's where I'm a little bit confused.
Okay, so there, can you still hear and see me?
I can hear you. I can't see you anymore.
Okay, so it's just to dismiss the motion for to default and go from there. Might bring up the motion, then modify it on the 13th for supervised visitations.
Okay.
Did you get that?
I think I got that, because in your initial pleadings, you asked for a particular type of relief, and with a default, you can't change. Like, okay, now I asked for this, and I'm changing it. So you
Right.
get what you asked for if you went on the default, and then if you want to change that, then you'd come back on April 13th to modify it.
Okay. Yeah.
Is that what you're thinking?
Yes.
Okay. So that makes more sense to me after having you explained that to me. Let me just go on the initial motion here for your parenting plan. So here back on August 9th, you filed a parenting plan, a proposed parenting plan related to, is it Malaya?
Yes.
Okay. And it states that you're asking that there be limited decision-making, that you'd be in charge of school, education, and healthcare decisions.
Yes.
And that you would be nominated as the primary custodian, and that she would have, Ms. Young would have visits on Friday at 6 p.m. to Sunday at 6 p.m. every other weekend.
Sounds right.
Okay. And then you've got some holiday schedules set in there, and that the exchanges would be up in Toledo, a house up in Toledo. And so that's
it's a truck stop, but yeah.
Oh, CG's.
Yes.
Gotcha. Okay. All right. So that's what you're asking for. Okay, good. I think, thank you for your patience and helping me work through that. I appreciate that. Okay. Mr. Miller, has Ms. Young appeared at any of the hearings since the case has been filed?
Yeah.
So one thing that I was looking at on your proposed order for the default, it says, it's talking about notice for Ms. Taylor or for Ms. Young. It says the other party, Ms. Young, is entitled to notice of this motion for default because she appeared or was served with the summons more than a year ago, which I don't think that's accurate, because it's not been more than a year. So the other option is that she's not entitled to notice of the default motion because she hasn't filed a notice of appearance, and she has not appeared in this case in any other way and was served with the summons and petition a year ago. So I'm a little bit concerned that since she has appeared in the case, usually a default is like the other party says, whatever, or they don't contest what you're asking for. And so they don't show up for anything and just say that what that person wants, I'm okay with that. Here, where she's, go ahead.
I think she was more kind of explaining like she hasn't responded to the case. So like she's not there.
Right. She hasn't formally responded.
Right. So I think that not more or less like she hasn't showed up to the case, just more or less like she hasn't responded. Like she showed up to court multiple times, but just never responds.
Right. Right. And it looks like the contempt issue has already been decided. So we don't need to decide any contempt issues today because that was decided back on the 16th of March. Okay. All right, bear with me one moment. Have you, that when we're talking about that hearing on the 16th or on the 13th, Did you send her a copy of that notice for the hearing on the 13th?
Yes.
Okay. And then did you send her a copy of today's hearing or a
I did.
Notice of that?
Yes, I did.
So the one thing, Mr. Miller, I'm inclined to grant the motion for default if I have a showing that she was given notice of today's hearing. Do you know if you filed some type of proof of service?
Well, so like, was this hearing scheduled from the last court date?
Good question. Let me check.
Because if that's the case, then she was most definitely aware.
Okay. Yeah, let me look. Last hearing was on March 16th. So I'll pull up the minutes from that date. She was present. You were present. And the court set the default hearing over to today at 9 o'clock. Court denied the contempt, rules on medication, third-party communication, disparaging remarks, sign a bench order. So that was done. And she was present, and we set over the default to today. There was quite a bit of discussion at the last hearing about the default, and she was present with the limited legal technician, Ms. Balcher. Yep. And the court set the default out to the 30th today, and then y'all talked about the contempt, not providing school clothes, visitation, Commissioner Cotterell, child support. Okay, so all that, and that set it over for today. And usually when a case is set over, the parties are present and there's an indication that this case is going to be discussed today and that something would be filed. So I'm going to say that there was
she was aware of it.
Yeah. I think that's true. So. Go ahead. Okay, let's see. Thank you. Thanks. Mr. Miller, the clerk kindly pointed out to me that on March 27th, it looks like Ms. Taylor filed a response to the parenting plan request. And she indicates that there's agreement in some portions and there's disagreement in other portions of the proposed parenting plan. So right. I think that puts us at a position where that since she's responded, the motion for default is, I think I need to deny that since she filed a formal response. We still have the hearing set on this coming 16th or the 13th, I think it is, the 13th, to address the parenting plan.
But I mean, she's still not here today.
She's not.
That's now we go back on that question of you asking me, like, what do I mean by how she's not present in court? This is a good example of how she's here, but she's not here.
Right. There's kind of a pattern of not being present.
Right.
Yeah.
So I mean, like, and that's what I've been fighting this whole time.
Mm-hmm.
That's why my end is being prolonged.
Yes. Yeah. Yeah, and I can't disagree with you. I think here that the fact that somebody doesn't show up to court is somewhat frustrating. With the default, it's a little bit different, because with the default, basically there's not a formal response, and that's what the court's looking at, because sometimes people just say, I don't care, do whatever you want, get whatever order you want, and then the court do that. But that's not the case here. So she's filed a formal response which says, okay, there is something in dispute, that the two parties have divergent views on what should be the outcome of the case. So since she's filed that, and it would be very good if she were here, but she's not, so I think that's enough to deny the motion for default, simply because the court looks for at least some formal acknowledgement that there is a dispute or there's not a dispute. She's saying there is a dispute. Okay, so that means the case goes forward. So if with the docket notice sent out for the 13th, then we'll be here on that date to consider the motion that you filed.
Okay, I want to put on the record that she was not here today, though.
Yeah, clearly.
And it follows a pattern of her.
Yeah.
Okay.
Yeah, that's fine. Okay. Yeah, the clerk's minutes they always reflect who's present and not present. It'll reflect that Mr. Miller is here, and Ms. Young is not here. Okay. Notwithstanding the notice that she had that we were going to send it over to today, she's not present.
Sounds good to me. But so nothing's changing though on my end.
Right, as far as the motion
until the 13th.
Right.
Okay.
Yep, that's I think that's an accurate portrayal.
Okay.
Okay. All right. Thank you, sir. We'll see you in 2 weeks.
Thank you, Your Honor. Have a good afternoon.
Take care.
Cameron Miller and Taylor Young.
Taylor Young's here with me, Your Honor. Diane Lefker, limited license legal technician.
All right, and Mr. Miller, I see you're here. Good. Just a moment here. So there's a motion for temporary orders, a motion to appoint a guardian ad litem, and then the motion was to terminate a restraining order. I think procedurally where we're at is there's a temporary restraining order, and we're here today to actually hear the motion for the restraining order, and however that is entered, if it's entered.
Yes, Your Honor. And then the motion is for the hearing on the 27th. It just, all of it kind of flowed together.
Okay. I think we need to hear the evidence on the restraining order first. And we typically will do that by placing the parties under oath. So, Mr. Miller, I believe you're asking for the restraining order. So I'm going to place you under oath and hear from you first. And then Ms. Young, I'll place you under oath and hear a response. Okay? All right. So, Mr. Miller, do you want to raise your right hand, please? Do you swear or affirm to tell the truth in these proceedings?
Yes, Your Honor.
All right, thank you. What is your full name, please?
Cameron Christopher Miller.
Mr. Miller, is everything that you stated in your request for a restraining order true and correct?
Yes, Your Honor.
Okay. Tell the court why you're seeking a restraining order against Ms. Young in this case.
Well, let me see. Like, how do I explain this? I've had my daughter for the last 2 years being down here, and I don't have my paperwork right here in front of me. So I've had my daughter down here the last 2 years of me working down here and me being in Cowlitz County. Taylor has DV stuff going on up there. She's got protection orders against people up there, and I need to make sure that my daughter is safe and in a good personal dwelling and staying in school, and she's not in any chaos environment. Like Miss Young had an incident up there at her personal dwelling where there was a DV case. You know, I put all that in there, I believe. She has, I believe that was her boyfriend or something like that, whoever it was up there. But there was a domestic violence case reported. So she had to go get a restraining order on her ex, whoever named Drew Sturrett or something, you know, and my daughter's seen that. And my daughter brought that to my attention, not to my attention, but also a teacher at school. And the teacher's called the CPS worker, and the CPS worker is now doing her job on that.
Okay. So you're saying your daughter witnessed the domestic violence between Ms. Young and this Drew person?
Yes, she had witnessed something to come back to me to tell me and to bring it up to a teacher at school, to where the teacher thought that that's what was going on in our home, which I had to correct that. Me and my girlfriend had to correct that. Okay. To where I had to go and hunt down police reports, evidence of the incident that my daughter was talking about. And it is an actual legit event that happened at Miss Young's dwelling. Yes, that my daughter has knowledge of. I mean, she's 7. She's not going to lie. I'd be like, she's not going to lie about big stuff like that. She might lie about taking the candy out of the drawer, but she's not going to lie about something like that.
Well, and you were able to document it with police reports, it sounds like.
Yeah, I submitted everything to you guys.
Okay. You don't personally have a fear of Miss Young at this point, is that right?
Oh, no, I believe she would come to my house and start a whole ruckus. Absolutely, I do.
As relating to your daughter, though, right? Or do you feel threatened by her personally?
As she would harm my daughter? Yes, by not giving her medication and stuff like that, and not bathing her. All of it. Absolutely, there's harm there. Absolutely, there's fear there. No, there's no doubt about it.
Okay, I guess I'm just wondering if you personally feel that you are at risk as a result or relating to Ms. Young.
Yes.
Okay. All right. All right. Anything else?
One moment. Oh, okay. So yeah, she has assaulted me previously. You know, like in the past. If you guys, I put that in there too.
Okay. All right. Thank you, Mr. Miller. You'll have a chance to respond to Ms. Young when after she makes her statement. Ms. Young, do you want to raise your right hand, please? Do you swear or affirm to tell the truth in these proceedings?
Yes, ma'am.
Okay. What is your full name, please?
Taylor Carmel Lorraine Young.
All right, thank you. You've heard Mr. Miller, and I assume you read his petition requesting a restraining order.
Yes.
So how would you like to respond?
I would like to, I 100% disagree, because what he's talking about, the domestic violence, happened when Malaya was not there. She's never seen anything. She's never heard me and Drew yell. She might have, I'm honestly being honest about, she could have heard me over talking about something, but she's never witnessed anything. And
that's documented in the police report.
It's documented in the police report. And she was not there that night it happened either. Also, the restraining order, there's now one, and I thought it was in the beginning because from history with Cameron, as soon as the police were involved, there was a restraining order in place. Well, when the police came, and the next day, a lady called me asking if I wanted to press charges and everything, and that he was going to have court on a certain day. So I got under the impression there was already a restraining order. Didn't talk to him, haven't nothing. Then I get an email after we already went to court from the lady who called me from the court stating that he's been picked up and he was in custody and that there was a restraining order. And so that's where we are now. But my kid has never seen domestic violence and has never seen me and Drew fight either. But she's seen me and her father fight.
How long ago was that?
Like last year, like when we've been in contact, me and Cameron can't be in the same facility without there being issues. But as soon as that happened, I let it go. I've had domestic violence in the past you've read in the reports from Cameron, and I have not had contact with you ever since I saw those red flags, have not been involved since. And he never lived at the house.
You haven't seen your daughter for a few months now?
Yeah, about a month now.
About a month, okay.
And this was right after the last hearing.
And this was right after the last hearing. So I think it's in retaliation because he didn't get what he wanted. I've done everything that they wanted. I have my own place. She has her own room. I've done everything. I'm in the best point of my life now than I've been in my kid's entire life. And he's not letting me be a part of her life. And that is the problem.
All right, just hang on a moment here.
And he's the one with the warrant out for his arrest. What if he gets pulled over and my kid's in the car? Where does she go?
Can I state something, Your Honor?
Yeah, I'm going to give you a moment here. I'm just looking at the temporary parenting plan. Just give me a moment. So, Ms. Young, it looks like prior to this temporary restraining order being entered, you would see your daughter Friday to Sunday?
Yes.
And then I know I entered an order requiring that you provide the correct amount of medication for her.
Yes.
Okay. And then the temporary order on the restraining order was entered and that stopped those visits, right?
And I missed her for Easter. I didn't have her for my weekend, and she missed my dad's funeral.
Okay. All right, I'm going to give Mr. Miller a chance to reply.
Okay, so I want to put on the record that there was another court date that she missed just before this one. So I want to put that on the record because I'm pretty sure that the judge put on the record that she wasn't there. And then also, I don't have any DVs. Okay, I want to put that on record too. Miss Young has DVs. I want to put that on record that she pepper sprayed me and my daughter. So I don't know what she's talking about, not having no DVs. The city of Centralia put a restraining order on her against me with my daughter. I want to put that on record, okay? And then, I don't drive around with my daughter in the vehicle. My girlfriend does that because I drive all day at work, And also, my warrant status has nothing to do with Cowlitz County, okay? And I haven't been in trouble with the law for over 3 years now going. And I've been doing pretty good working down here in Cowlitz County and doing tree work and stuff, and my daughter's been doing pretty good down here in school, The other thing is while we're all under oath, okay, Taylor's declaration is pretty false advertisement. I want to state that.
In what way?
How she says that there was no domestic violence in her household with that Stewart guy. You can read her declaration and then you could go and read the legit police report and they won't add up. And then you can also go and read Melicia's police declaration, and she'll state that there was never, Drew has never hit her physically or anything like that. That's false, because Melicia states to the police that Drew hit her the day prior. And then Rhonda's allegations, those are actually pretty wrong too, because there's recently a new guardian ad litem out of Lewis County, I believe like 2 years ago, that Rhonda stated a whole bunch of other stuff too. And just like Miss Young, how Miss Young states that she's in fear for her life or whatever with me and blah, 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 blah. She actually tells the guardian ad litem in Lewis County that she's not. And, you know, and that we're co-parenting and all this and blah, blah, blah. So she's really out for a reach, it kind of sounds like, you know, and I'm pretty sure I put in messages, I submitted messages stating how I didn't force Taylor to sign a parenting plan, like a mutual parenting plan between us, because she went to a notary and had it done herself. Just like I went to a notary and I had it done myself. She also gave power of attorney and custody over at a time to my sister, and signed the exact same kind of paper that me and Taylor came up to sign. But the one with my sister, I did not sign. You know, that's the thing. All of a sudden, Taylor wants to sit there and say that I'm out for like retaliation or whatever the heck she's trying to say. No, I could care less about that. Okay. It's about my daughter, for one. So how she's like, she was not here at the last court date. Dude, I want to state to that. So she's like coming in and out of it.
I saw that in the court record.
Thank you.
Your Honor, I was aware, I thought the court date was on the 31st.
And you had already filed.
And I already filed my response.
No, she was there.
All right, we're not gonna.
The judge asked me, Your Honor, the judge asked me that day on the court date, did Miss Young know about it? And I looked at him and I stated, I said, I'm not sure. Is this a court date that I sat, or did you guys sit? Because if you guys stated it, then she most definitely knew about it. And he went back and he looked through his computer and he looked at me through the monitor and says, you're right, we set this. She absolutely did know about that.
All right, let's focus on the restraining order issue. My focus on this decision is I want to make sure that the daughter is protected. And so I'll acknowledge that there's in 2022, there was a temporary parenting plan issued. Apparently the parties followed that for a while. Then they came before me because of an issue relating to the administration of medication. I made an order relating to that. Apparently there were visits going on, certainly into 2023. And then recently, Mr. Young has filed for another restraining order. He's provided evidence to the court of police reports that suggest that there was domestic violence occurring in Ms. Young's life. And that raises a concern in it, in my mind, supports a limited restraining order. And it's going to be limited as to time. One of the other requests by Ms. Young is for the appointment of a guardian ad litem. Mr. Miller objects to that, but given the allegations of the parties, the concern about the domestic violence in Ms. Young's life, I think she has some concerns about Mr. Miller a guardian ad litem is absolutely important in this case. So I'm going to enter a restraining order that will prevent Ms. Young from seeing her daughter. I'm going to enter it for up to 90 days. It may be that less than that, I'll change it. I also want her to be able to have telephone or video contact with her daughter twice a week during that time. And I'd say up to 90 days because I'm not sure how long the guardian ad litem report will take to generate. That could take a while, but it can be done in 60 days and we can make some decisions then probably simultaneous with getting that report, I would lift the restraining order and we would look at another type of parenting arrangement. Well, let's take care of appointing the guardian ad litem at this point. So what we usually do is give 3 names. And if you happen to know any of these parties, you have the ability to strike 1 name. So the names are
Twyla Corey, Keith Lawrence, and Heather Call.
All right, so I'll repeat that. It was Twyla Corey, Keith Lawrence, or Heather Call. Do any of the parties know any of those folks? Okay.
No.
All right. So typically then we would appoint the first person on the list. So that will be Twyla Corey. I will give her your contact information and then she will reach out to both of you and do an investigation. Initially, the order will require that you both pay half of her costs. If you're receiving state assistance or you cannot afford her costs, you can file a declaration with the court and I can consider that and potentially have the county pay for your half of the costs on that. Okay.
Can I ask something?
Sure, go ahead.
Okay, so in Miss Young's part, she did state that like I pay her portion. Yeah, how you just stated that like the county will pay her portion. That's correct, right? Like I'll pay my portion, but I don't want to pay her portion.
If she probably asked for that, I'm not ordering that, and I hardly ever order that. I think both parties need to have some interest in the guardian ad litem, and I think having one party pay for it gives the other party a chance to say, well, you know, since they paid for it, the guardian ad litem is slanted their way, and I don't want that to ever happen. Okay. So it's very rare that I have one party pay the whole fee. But if Ms. Young cannot afford her half, then she can again file a declaration, and I can consider it.
Your Honor, we do have a hearing coming up on the 27th where we filed a motion for an amended parenting plan. That's where we were going to address the guardian ad litem. However, it is very restrictive to have no visitation and phone calls when this domestic violence did not occur when the child was there, as noted in the police report, and never was on the lease. Mom should have some visitation, even if it's at her mother's house, where the child isn't being restricted from the mother. In light of this other hearing coming up, it does take a long time to get a guardian ad litem, and we do want a guardian ad litem to be reviewing everything because there is serious history of domestic violence and criminal events in this case. There's manipulation.
Why is she talking? I thought she was
Mr. Miller, just hang on.
There is definite retaliation because the motion that he filed was directly after you denied him his contempt. And so she hasn't even had time to have time with her daughter. She should have some visitation, even if it is supervised, if that's what you want to do outside of her home.
Because I can stay at my mother's on my visits, and that's surrounded by my grandparents and her. I don't have to be in my home, but I can't go not seeing my kid.
Mr. Miller, any thoughts from you on?
Yeah, I got a lot of them. So for one, I got a question. Is that lady a lawyer or just a legal technician?
She's a legal technician. I'll let her speak.
Is she allowed to speak? Because
she is.
So when I last looked them up, they weren't allowed to speak. They're just there to do paperwork to help you, not speak.
All right, let me ask.
So the other thing is like, yeah, I'm not okay with any of that because her grandparents and her grandmother, they all talk bad about me too. So, and they still allow Taylor to take Malaya places, even if the courts said no. So no, I'm not okay with that because that's happened in the past.
All right, here's my concern about, I guess what was just indicated is the record that I've looked at on this motion shows that there is some domestic violence that's affected Ms. Young. And that could affect the daughter. And I need a guardian ad litem to look into this before I feel comfortable making a change at this point. So I am not going to order supervised visits at this point. I think if a guardian ad litem looks at this and even before the report is issued indicates that would be safe, I'll consider it. But at this point, I'm going to have the two either telephone or video visits until we get a guardian ad litem reflection on this case. Do we need to set specific dates for the telephone and video visits and dates and time, or is that something?
I would like to at least do one video call where she can watch Malaya at practice, please.
At practice, meaning sports practice?
Yeah, softball practice.
Well, how is she going to be able to talk to her then? I mean, the whole purpose is for her to communicate with her daughter.
That's right.
If you want to Zoom her in or FaceTime her in to watch her practice, that's great. But I think there needs to be 2 times where Miss Young can have a conversation with her daughter.
What do you got? I mean, yeah, any day that's okay with her. Malaya is at school from 8 to 4, and then after that, she's home. Malaya's got softball practice on Mondays and Tuesdays at 5:30 to 6:30.
Miss Young, what dates would work for you?
Thursday, and I can do it anytime.
The first game.
Okay, so Monday and Thursdays at?
I think Monday, what time?
6:45?
6:45, 5 o'clock.
Let's do 6:45 because she's at practice, I think 5:30 to 6:30.
Next Monday, is that the 17th?
I believe so.
That's going to be Malaya's first game at 6 p.m. to 7:30.
Well, there may be dates that get in the way. So let's say.
No, that still works for me. It's fine. It still works for me.
How about Monday and Thursday at 7 p.m.? And if the game gets in the way, then it will be whenever the game is over and she's back at the house.
Okay.
All right. I still want it to occur on Monday and Thursday.
Yes.
All right.
Monday and Thursday at 7 p.m., Your Honor?
Let's do 7 p.m.
Okay. Thank you.
For how long?
And for as long as the daughter wants to talk.
Okay.
Okay. And Mr. Miller, you're not to interrupt that. You're to provide a space where she can talk to her mother on her own. Okay.
In private?
Yes.
In her room is fine. in private. I don't want the child to feel like somebody's looking over her shoulder.
Okay.
Okay. All right. I'll do a bench order then. In fact, I'll appoint Ms. Corey. Let's set a review. Well, we have a hearing coming up on the 27th.
Yes.
Okay. I'll just see everybody back here then at that hearing, and then we'll set a review out from there.
Okay. Thank you,
for the guardian ad litem. All right. Thank you.
Ms. Young here.
Your Honor, my name is David Camisa. I was just hired to represent Ms. Young on this hearing today. I'm putting in my notice of appearance shortly, but I'm prepared to proceed today.
Okay. Mr. Miller, you're here. I see Mr. Miller's got a motion to waive the GL fees. That is going to be heard next week. So we'll deal with that next week. Well, I don't see the guardian ad litem, who is Twyla Corey, here, and I wanted to hear from her regarding visits with the mother. But Mr. Camisa, if you want to be heard on that, you may.
Yes, Your Honor. I'll be brief. Here, the court entered a temporary order requiring Ms. Young to only have Zoom visits with the child. Ms. Young respectfully requests that this order be amended to the original plan with unrestricted access to time with the child. Here, the court had concerns about a recent incident of domestic violence in the Young home. The incident involved Ms. Young's new domestic partner kicking in a door. However, this incident did not involve the child. In addition, the child was not present during this incident. Either way, there's no domestic violence charges against Ms. Young and the child, nor any convictions involving the child. In addition, we do not have any CPS investigations, nor any substance abuse present. Ms. Young has in fact missed 6 weeks with the child pending a GAL report. In fact, a prior GAL report in Thurston County actually awarded her full custody. As such, this GAL report will likely reflect a positive ruling for Ms. Young. It's in the best interest of the child to have unrestricted access to time with both parents, absent any limiting factors which are not present here. Ms. Young has a 2-bedroom apartment and was the sole provider for the child for 5 years. The child would have its own room. The petitioner was absent from the child's life during this time for 5 years. The child is in fact 7 years old now. As such, the petitioner has only been involved in the child's life for 2 years. The petitioner does not have an adequate residence for the child. The petitioner lives in a 2-bedroom apartment with 3 other children living there. As such, given that no domestic violence against the child is present, and Ms. Young has been the sole provider for the child for most of their life, I would ask the court to remove the requirements that Ms. Young only speak to the child through Zoom and award her sole custody.
Absolutely not. All right, so is it my turn to speak now, Your Honor?
It is. Mr. Miller, go ahead.
Okay, so I just want to go back on whatever he was saying about Miss Young being the sole provider for 5 years. That's wrong. She hasn't been the sole provider for 5 years, actually. My sister actually was there for 2 years, okay? And he also needs to go back to like the Thurston County thing, where the guardian ad litem granted her custody. That's false advertisement, because there was a Thurston County case, there was a Lewis County case. Oh, wait. And in the Lewis County case, they still deemed me the right parent, okay? So, and then the other thing is you can't sit there and say like she doesn't have any custody, domestic violence cases against her, because if you need my proof, I will send it right over to you from Centralia PD that states that she did pepper spray her own daughter and me in my own home, in my own personal dwelling. And if you think I'm wrong, that means you're telling me that a public servant's records are wrong. That's not true. The other thing is, is it doesn't matter how many children are in my home or how many bedrooms I have, as long as they are all sleeping properly. I don't have my son sleeping in their room. It's 2 7-year-old girls and they both have their bunk beds. Who in their right mind is all of a sudden saying like that's not okay? It's not like I have a 7-year-old and a 7-year-old boy living in the same room. Absolutely not. So that part needs to be thrown out too, because that's false advertisement. And the other thing is like I said, the last court date, Taylor's letters of recommendations, they're all false. You know, you can read them and then go read police reports. None of it adds up. None of it adds up. And I've been in Cowlitz County for over 2.5 years now. Okay. And I've been stationed and I've been pretty stable. You know, I don't go from job to job. I don't go from apartment to apartment. I'm stable. I'm planted. I'm rooted in Cowlitz County. And I've talked to the GAL last Thursday to set up an appointment on that. But, and then about like her missing her visits on Zoom. Taylor is 27 years old. She was at the last court date when the judge set the court dates for video Zoom. And she still does not show up. She comes up with excuses. Like if a 7-year-old can remember the days and the time, there's a problem. It kind of sounds like she's honestly not doing what she's supposed to be doing, like I've been trying to tell. Because there's no way in heck that a 7-year-old is able to remember the time and the date of the Zoom meetings. And you as a parent are just constantly, oh, I forgot, it's not working, blah, blah, blah. Well, they're like excuses. Everybody's got them. Sometimes your excuses run out.
Okay. Thank you, Mr. Miller. Mr. Camisa, any response?
Yes, Your Honor, I'll be brief. Analyzing the petitioner's recent testimony, he quoted, according to his own testimony, his sister's involvement in her life during that 5-year gap, not him. This was specifically referenced within his testimony recently. Regarding the Thurston County GL report giving Ms. Young full custody, that's referenced as an exhibit. I could bring it up more, but I believe the court has already seen it.
No, you're wrong. Because Miss Young signed
Mr. Miller, Mr. Miller, one at a time,
up to me.
Mr. Miller, Mr. Camisa's speaking. Go ahead.
Thank you, Your Honor. I'll only have a few more things to say. In regards to the petitioner's claim of domestic violence, I would expect him to submit proof of that before just dropping it on the record. Without such proof, it's irrelevant. Moving forward, analyzing his personal living situation, it clearly does matter if the children have their own bedroom. It clearly does matter if there's 3 children living in one room. It matters if there's 5 people in a 2-bedroom apartment, especially when 3 of them are young children.
Girls is not an issue.
All right, let's stop. Mr. Miller, you're going to stay quiet while Mr. Camisa speaks. Otherwise, I'm going to mute you and you're not going to get any more to say during this hearing, okay? There's a decorum that we're going to follow and you're going to follow it. You understand? All right, Mr. Camisa, continue.
Thank you, Your Honor. I would just close and say I respectfully request that Ms. Young be allowed time to speak to her children without Zoom and be awarded sole custody as she's had for 5 years present to this hearing.
Mr. Miller, if I were to consider a supervised visit, is there someone that you would trust that could be involved in that?
Yeah, my sister.
Ms. Young, would you be comfortable with that as what I could do until I hear from the guardian ad litem?
Yes, Your Honor.
Okay. All right, I want to leave the video visits in place. The history of the Cowlitz County case is that Mr. Miller has had primary custody all through the case. And I have seen the different orders from, I think, Thurston and Lewis County. But I think I need to track what we've done here in Cowlitz County until I hear from the guardian ad litem. Unfortunately, she's not here now. We are going to be back next week on Mr. Miller's request to waive the guardian ad litem fee, and I'm going to try to make sure that she's here then. What I would like in the interim, today is the 27th, I would like a visit with the child on Saturday. Let's go from 10 to 2. And in the future, I may expand that if we continue to have supervised visits. But from 10 to 2, supervised by Mr. Miller's sister.
All right. It would need to be like 9 to 1 or like 8 to noon. I believe my sister works at 2.
Okay. Thank you for letting me know that. Ms. Young, can you make it 9 to 1?
Yes.
Okay. So we'll do it 9 to 1. If the sister can do the transporting, I think that would be best so that Mr. Miller and Ms. Young do not have to contact each other.
Your Honor, would it also be okay to be at my grandparents so my grandparents can see her? He knows that is a safe environment.
I don't see a problem with that as long as the sister is with you at the same time. Okay. All right. Just hang on. All right. Then we'll check in with everybody next Thursday to see how that particular visit went. And I may consider expanding it a bit at that time. Okay. Everybody understand?
Yes, Your Honor.
Yes, Your Honor.
All right. Thank you. We'll see you next week. All right, Cameron Miller and Taylor Young. No, I saw him just Young here.
Your Honor.
All right, good morning.
Your Honor, this is David Camisa. I'm here for Miss Young this morning.
Okay. Ms. Young has brought a motion to waive the GAL fees. Do you want to address that, Mr. Camisa?
Yes, Your Honor. Ms. Young is experiencing financial hardship as seen in the motion and just asked the court to waive the fees for the GAL.
All right. Mr. Miller, do you have any comment on this particular motion?
No. I still need to get my GL part done now.
All right. So I've read the motion. Let me turn to. So Ms. Young has indicated that her gross pay each month is $26.78 and her take home is $23.08. And she supports 2 people, herself and a child. And the guidelines for 125% of poverty level, which is at the point we can waive the GAL fees and have the county pay for it, is $2,066, and that's gross pay. But even if we looked at that in terms of net, she's above that threshold.
Can I state something, please?
Sure.
So how does she support 2 people if Malaya resigns with me? That would contend that she only has herself that she takes care of.
Okay, well, we get to the same place here, which is she, even on a net basis, is making above poverty level. And so at this point, I cannot grant the motion.
And let me ask you, do you know if she's receiving any state benefits, Mr. Camisa?
No, Your Honor, I don't believe so.
All right. So based on the guidelines that I have, I'm going to have to deny that. Let me hear from Mr. Miller, and then Ms. Young, I'll hear from you. Mr. Miller.
No, I don't have anything to say right now, Your Honor.
All right. Ms. Young, go ahead.
I was gonna say I did before refute. I had food stamps, but those were canceled like back in February.
Okay, but you don't receive them now, right?
As of like 2 days ago.
Mr. Miller, how long have you been the primary parent?
With Malaya?
Yeah.
I'm going on 3 years now.
Okay. All right.
No.
Well,
I'm not going to argue.
Again, I was given a declaration of what the earnings are. The earnings are above the threshold that I have to work with, even assuming there's 2 folks in your household. So I'm going to deny the motion. All right. Thank you. Next up, we have Pamela Pascal.
Oh, wait. Hey, Your Honor, sorry. Am I free to go?
Yes, you're free to go.
Oh, okay. Thank you.
On to the next case.
Bye.
Okay.
That judge is a fucking.
All right, I'll do that. Cameron Miller and Taylor Young. I see Mr. Miller. I see Ms. Corey. Mr. Camisa, you're here for Ms. Young, I take it?
Yes, Your Honor, that's correct.
And we need to know, is Ms. Young here? We just need to reflect that in the court minutes.
So I have a question about that. If we're on the self-represented docket and she's self-representing, how come is it that those guys are always allowed to speak for her? If we're on the self-represented docket.
So attorneys can appear for clients in this docket.
I've never got anything saying that she was being represented by him.
Just a moment here. Have you done a notice of appearance, Mr. Camisa?
No, Your Honor, I'm just filling in to help her.
So you're not her attorney?
Are you a lawyer or are you in?
Yes, Your Honor, I'm an attorney. I'm just filling in to help her. She's actually technically hired a limited licensed legal technician that works in our office.
Right. So,
and given the complexity of the case, I'm just filling in to help.
Right. You have no say here. Sorry.
I'm going to let him speak.
So she is being represented how though? Because the legal technician is just a paper pusher.
I understand that they fill out the documents, but it's through a law firm where Mr. Camisa works. And so I'm going to allow him to speak.
Okay.
All right. The last thing I did is I denied the GAL fee waiver on behalf of both people. There was a motion for a revision that got assigned to a judge yesterday. And there were issues with visitation that occurred over the last couple weekends, I guess.
So I got a good question about that part too.
Yeah, let me know where we're at on the visitations.
Okay.
Go ahead, Miller.
We're still doing the Zoom. Yeah, we're still doing the Zoom. And then the last visitation when she physically seen her was supervised visitation. And that's my most concern. So they were supposed to meet at the grandparents. She texted my sister to have her meet in Grand Mound at Walmart. And I'm under the impression when you're doing supervised visitations, it's with that supervised person and at one location, not out doing a whole bunch of running in errands. And my sister filled some stuff out stating that that's exactly what they did.
Apparently your sister indicated she was uncomfortable being at the grandparents' house. Have you talked to her about that?
Yeah.
So if that's the case, then...
So no, Taylor manipulated that whole thing to my sister. That's how that went about, because Taylor tried to say that I told her 9:30 when that's not what I told her. I told her 9 and to be at the grandparents' house. In the next court date, I'll have my girlfriend submit everything that I stated. Okay, because I stated it is at the grandparents' house. Nobody is to leave. That's not how it worked and all of that. You know, I even told my sister she didn't feel comfortable. Well, you don't have to do it. And I'll go back to court and I'll have the judge, what is that? The person that you can pay, I don't know, you pay a facility and then like
that's a professional supervisor.
Right. Okay. But all they did is run around and did errands.
I did read that, but I guess I'm wondering, is your sister uncomfortable being at the grandparents' house? And if so,
she's uncomfortable being around all of them.
Is there another location that we could set this?
No, we can do that person at that, the professional person.
So your sister's out of it at this point?
Yep. And that's just where I want to do it. I don't want no more games. I don't want no more hassle about it. If I have it at the facility, then I know there's just no ifs, ands, or buts about it.
Mr. Camisa, do you want to respond?
Yes, Your Honor. According to Ms. Young, she's reported that Mr. Miller is engaging in conduct that is obstructing her time with the child. According to Ms. Young, the in-person weekend visitations were at the last minute. Mr. Miller changed the location and the time, which is very concerning considering it's something that was agreed to just basically a few days before that. In addition, during the weekly Zoom visits,
I hope you got your facts straight.
Ms. Young was
Mr. Miller, you need to remain quiet while he speaks. Go ahead, Mr. Camisa.
I'm almost done, Your Honor. Miss Young reports that she was not able to exercise her visitation as the child couldn't come to the Zoom as they were showering after a sporting event. In addition, Miss Young reports that she gave a photo or a painted picture of the child detailing love and affection that Mr. Miller gave away. The only thing I would really ask is that with Mother's Day coming up this weekend, that Miss Young be allowed to see the child. However that can be achieved. If it could be done without a professional supervisor, that would be great. But if a professional supervisor is necessary, I would just ask that Mr. Miller bore the costs of it. Or alternatively, the costs be shared between the parties.
So can I speak again now, please?
Go ahead.
Okay, so, I will admit, I put a fan in my room. Okay, there's nothing wrong with that. And I told my daughter to sit down on my bed. So there ain't nothing wrong with that either. And I won't be paying for Taylor to see her child. Miss Young can pay to see her own child. I'm not going to split the cost on nothing. Nothing about that. And I did not switch the visitation. I didn't switch no meeting spot, no nothing. I texted my sister and I said, if you don't feel comfortable, cancel it. I have no problem with you canceling it, and I'll go right back to court and I'll tell the judge that. So somebody needs to get the facts straight, Mr. David.
All right, I'm not going to have any sarcastic comments on this docket, Mr. Miller. All right.
Well, it's just really getting
Mr. Miller,
old with like them saying what they think I said when I know I did never say that. I have text messages.
I'm ready to make a decision. I don't have anything from Mr. Miller's sister saying that she doesn't want to be involved in the visitation. And consequently, I'm going to assume that she's still willing to do that. I'm going to order a visitation this Saturday from 10 to 2, supervised by Mr. Miller's sister.
Okay, so I need to check with my sister if she's willing to do that right now.
And that can be at a public location.
I need to check with my sister.
A park. It's going to be a nice weekend. Doesn't have to be at the grandparents' house. It can be at a public location.
Okay, and if my sister doesn't want to do it?
Your Honor?
Just a moment. Then she'll have to file a declaration with the court.
Who, my sister or
yes.
Taylor?
No, your sister.
Okay, that can be done.
Okay. Ms. Young, I think you wanted to say something. Typically, when you're represented by an attorney, that we have the attorney speak for you.
Yeah.
All right. The drop-off on Saturday will be at the grandparents' house, and then the sister and Ms. Young and the child can go, and Malaya can go to another location. Okay. All right. Thank you, everyone.
Your Honor.
Yes, Ms. Corey, please.
This was also supposed to be a GAL compliance review.
Okay, I'm sorry I didn't give you time to speak. You want to give us an update on that?
Sure. Actually, this case has just recently received it. I have intakes out to both parties. Just this morning received Mr. Miller's. I have not yet received Miss Young's intake. Also, I've spoken with both of them and indicated that payment is due this week, and made arrangements for that. Have not seen payment yet, and would ask the court to schedule another compliance review in a couple of weeks to assure that we have gotten the payment process started and that both parties are cooperating.
Okay. Ms. Young, I want to encourage you to get the intake paperwork back to Ms. Corey as soon as you can. Ms. Corey's asked for a review in 2 weeks. That would be on May 25th. So I'll see both parties back here on that date. Okay. All right. Thank you. All right. Cameron Miller and Ms. Young. See, Mr. Miller's here. Taylor Young is here, and Mr. Camisa is here. Let me start with Ms. Corey. Have you had a chance to investigate this case? And if so, where are we at?
Well, I have not. And neither party has, as of yet, made effort toward paying the GAL fee. I have received completed intakes from both parties, and I did also make arrangements with them to pay the fee in lesser payments. I have not received any payment from either party as of yet.
All right. Mr. Miller, are you planning on making that payment?
Yeah, it's just slipped in my mind. I've just been busy. I can make it by Monday or today.
All right, thank you. Ms. Young, are you? Go ahead.
I did speak with Ms. Young yesterday. I apologize. And she indicated that she has a payday early next week and hopes to be able to make a payment time. However, I'm thinking that this has really been a struggle for both of these folks, and we learned that county pay was not an option. I hesitate to keep that offer of partial payments because this has been so difficult too.
I'm not sure what you mean when you say you hesitate to keep the offer of partial payment. Are you looking for full payment?
I would say that if I don't receive the agreed to payment within the next week from both parties, that I would have to rescind that offer of a payment plan and ask for full payment.
All right. I saw the declaration from Victoria Miller. What happened regarding the visit this Saturday, last Saturday? Mr. Miller, you can respond.
Well, I tried to explain it last time that my sister just didn't want to have anything to do with it. And then you told me that she had to fill out the declaration stating that she didn't want to do it. And that's where we are at.
Okay.
I did find, I believe I have somebody else that's willing to do the visits. So.
Who is that?
My next door neighbor, Cassie.
Okay.
No. I don't know who that is.
I need some information. So Mr. Miller, don't tell me the address, but where do you live? What city you live in?
Longview.
Okay. And Ms. Young, where do you live?
I live in Olympia.
You're in Olympia. Okay. And I saw a previous order where you did exchanges at GC's truck stop. Do you know if that's something that would be still be available?
I feel Centralia's even. It's a middle way from Olympia to Longview.
No, we can still do Gigi's truck stop.
And is Cassie, I'm not saying I'm going to agree to Cassie, but are you saying Cassie is willing to do that, be part of that transportation?
The transportation or supervised visit?
Well, supervised visits.
Yeah.
If
and the transportation, yes.
Okay. All right, Ms. Young, I'll give you a chance here and give your attorney a chance. Okay. All right, Mr. Camisa, do you want to address where we're at?
Yes, Your Honor. Given there seems to be a continued issue with the supervised visits, if Ms. Miller is largely unavailable to supervise, I was going to propose Ms. Young's grandparents be the supervisors.
Yeah, right.
There doesn't
took my
appear
daughter
to be
from me last time.
Mr. Miller, you need to remain quiet when the other party is talking. Thank you. Go ahead, Mr. Camisa.
Thank you, Your Honor. I mean, given that it looks like Ms. Miller is likely going to be ruled out as a supervisor now, I think having the grandparents step in is likely in the party's interest, given that we need to find someone to do the supervision. There's no real reason why they cannot do the supervision. I understand Mr. Miller doesn't want them, but at this point in time, there's no necessarily reason or even provable reason why they can't step up as the supervisor at this junction.
Where are their grandparents located?
Centralia, that's where the original place was that Victoria would meet us at. And Cameron knows that that is a safe environment. He knows that. Everyone knows that that is an okay place for my child to be.
All right, let's give Mr. Miller an opportunity to respond.
No, the grandparents, I'm not comfortable with it because when all of this whole stuff started, the grandparents were the ones who, manipulated me to give my daughter to them. That's 3 times running that they have done that to me. No. That is not even.
Ms. Young, you need to remain quiet. I don't understand what you mean by they manipulated you to get the granddaughter to you. What does that mean?
Okay, so like literally a week and a half before school started, the grandparents came down, asked to see their granddaughters, shoved her in the car, and then took right back off to Centralia. Oh, I still have the text messages that I will be putting in today from the grandfather, stating that I don't have any rights to my kid. The mother, she needs to be with the mom. I messed up somehow. That Malaya is not going to be coming back to me. Oh, yeah, that's all from Jim Bartley. So absolutely not. And if they don't want to have Cassie do the exchange, I'll be more than happy to go with an actual legal person at a facility that I'll have her pay for.
Tell me a little more about Cassie. How old is she?
She's about 35, maybe. I know she's in her between 30s and late 30s. How old is she? She's 33. What's your last name? Salisbury is her last name. And she's the girls' youth group. What? The girls' youth group leader at church. So I can't be angry and fight her. She's willing to do it. She said she's willing to do it, but it would have to be next Saturday. I'm willing to do Zoom this weekend. I'm going camping. I'll try to find some time. I'll try to find the service so they can talk on Zoom. But Cassie said she'll be willing to do it next week to start the supervised visitation.
All right. Ms. Young, you've heard this discussion. I guess I don't want to make a decision unless I give you an opportunity to make additional comments.
I do not know who this is, and the fact that Cameron doesn't even know her age or her anything, and that's the trusted person for supervised visits, I don't understand that. I work, I have my own place. There's absolutely no reason I should not be able to see my kid, nor my child loves her grandparents. If it is at my grandparents' house, she'll be able to see my mother, me, and her family all under one roof. It is a safe, clean environment, and he knows that. And everyone knows that. And this is starting to be about a month and a half of me not seeing my kid. I don't know what's being said on her end on why she's not seeing me. And I need to be able to see my kid.
All right. I agree with that.
Cameron his options. He's had multiple chances. I did it with Tori. I did it with everyone. I gave him his options and it's not working. And I would love to try my way. And that is to be at my grandparents' house. And I don't need supervised visits because we wouldn't leave.
I'm going to accept Mr. Miller's statement, though, about the grandmother's or grandparents' attitude towards him, which creates
He's threatened my grandparents. He's threatened to kill my grandfather. He's done all these things and they've done nothing. They never kidnapped her, ever. They never just took her from him. He just does this when he doesn't get what he wants and everyone has to pay for it. This is what happens when things don't go his way. He takes the people who love Malaya away from her when it doesn't go the way he wants it to. And that is just the truth.
So yeah, I will be putting in my text messages from the grandfather today, so we can get all of that cleared up.
I also have text messages and stuff. I only received that Cameron forged his sister's signature, and the statement is not correct.
That's falsely wrong. So I'll have my sister come to court next time too, I guess, and get her under oath and have her explain that part too.
All right. Let me go back a bit. The parties had and have a temporary parenting plan in place, which gives unsupervised visits to Ms. Young every other weekend. Then the issue with Drew Stewart came up, and out of an abundance of caution, the court suspended those visits in order to investigate the relationship between Drew Stewart and Ms. Young, and to make sure that Mr. Stewart was not in a position to cause any harm to Malaya. I appointed a guardian ad litem because of some delays in payment and other things. I really don't have a report or any indication from the guardian ad litem as to what is in the best interest of Malaya and what's going to keep Malaya safe.
Malaya,
I'm sorry. So
I haven't had contact with Drew ever since. There's a no contact order.
Ma'am, let me just keep going. I need to sort my thoughts, and it takes me a little while to think through them. Okay? All right. So at this point, the court feels that supervised visits are still warranted until we get to a point where I know that Malaya is going to be safe. When we initially set up supervised visits, Mr. Miller indicated his sister would be willing to do that. She's now said she wouldn't. And so we need to find somebody else. And I'm somewhat hesitant to appoint somebody that Ms. Young does not know. And it sounds like Mr. Miller doesn't know very well. On the other hand,
I mean, I know her. I just don't know like her age.
On the other hand, the whole time that Ms. Salisbury, well, at least most of the time she'll be with Malaya, so will Ms. Young. And it's hard for me to imagine that Ms. Salisbury would be any kind of threat to Ms. Young.
Would he be okay with my stepmom?
No.
I think I want to try Cassie Salisbury next. And honestly, the best thing that can happen is to get Ms. Corey paid so that she can do her investigation so that we can move forward with this. All right. Mr. Miller indicated that he's leaving this weekend. Do we have Zoom visits at 7? At some point?
That's what I meant. I'd try to find service for the Zoom.
Okay. Let's have a Zoom visit this weekend. Tell me what date and time that's going to occur, Mr. Miller, so that we're not confused about that.
Oh, we can do Saturday at 7.
7 p.m.
Yeah. Or
right.
Can we do earlier? Like 3 or 4?
I'll be at work.
Well, what time's good for you?
I get off work at 5.
Okay, we'll do 5, 6.
Better do 6. All right, Saturday at 6 will be a Zoom visit. Nobody should be interfering with that. That should be a discussion just between Ms. Young and Malaya. The next Saturday will be a supervised visit. And I'm just looking for an order here, just a moment. Oops. Growing up, and now we live in the find out era. So like we were born and we lived there for a couple of years, and like we just do it. There's money everywhere, and everything was great, and then now we're in the find out. I'm still going through the file here. Just give me a moment. All right. The next Saturday, and that's going to be June 3rd. I want Cassie Salisbury to meet Ms. Young at GC's.
Could we do a visit at her baseball game so I can see her at baseball?
Where is that? Down in Longview?
Yes, but I would love to see my kid play baseball.
Do you know when that is?
On Mondays.
Okay.
So how does that work with the restraining order, though?
There shouldn't be a restraining order.
I'll tell you in a moment.
I don't mind standing on the other side of the field.
Let's talk about the Saturday visit first. So are you going to want to go up either? Well, what would be your thought on what you would do with Malaya on the Saturday visit?
She wanted to go to the Hands-On Children's Museum last time I talked to her. That's what we were going to do. We usually go to the park. We went and got our nails done last time, but she wanted to go to the Hands-On Children's Museum.
And where is that?
Olympia.
It's in Olympia. Okay.
The door is open. Samantha's in her room.
Okay. All right. Well, let's meet at
Or we're going to take her to go see the Mermaid movie, The Little Mermaid. I'd like to take her to see that.
Okay. Let's meet at GC's truck stop at 10 a.m. on June 3rd. And we'll have Cassie Salisbury bring her there. And then Cassie Salisbury will need to accompany them on whatever outing they have. If that goes to Olympia, she'll need to go to Olympia. And then I'd like a return to the GC's point by 6 p.m. on Saturday. And then Cassie can bring Malaya back to Mr. Miller. I know that sounds a little bit convoluted, but I'm not willing to take a step towards unsupervised visits at this point till I hear from the guardian ad litem. And I want to do what I can in order to get you in-person visits with your daughter. In terms of Monday baseball games.
Sorry to interrupt. They just said that Cassie can do 2 to 5 on Saturday.
2 to 5?
Yeah, that's kind of short.
Cameron, can you please swallow your pride for once and know that is it okay that she's with my grandparents, and you know this. And with
the visit on
is
the
how
visit,
sorry.
The visit on Saturday is going to be 10 to 6. If Ms. Salisbury can't do it.
Okay, that works.
I really hope it works.
All right. The Monday baseball games, I'm going to allow, there needs to be a 50-foot distance between Mr. Miller and Ms. Young at the baseball game. Malaya will be able to come over, talk to Ms. Young, but obviously can't leave with her. And Ms. Young will be able to observe the game. You'll have to obviously be on separate parts of the baseball field.
Thank you, Your Honor.
All right. Okay. All right. So we'll do that.
And if Cassie can't do it on Saturday, what happens then? Because I didn't get to see her last week either.
I know. I'm probably going to have to put I hate having you come back so often, but it looks like I need to track this. We're going to need to come back on June 8th to see if that visitation occurred and to see how the baseball games go.
Okay.
I don't know that Ms. Corey's going to have any conclusion by then. Probably not, but I want to check to see how these are going. And if they don't go, then I'll have to make some other decisions. Okay. Yeah. Mr. Camisa, any comment at this point?
No, Your Honor. Sounds like everything's been discussed. Thank you.
All right. Thank you. I'll do a bench order to that effect. And we'll see everybody back here, I guess, in a couple weeks on June 8th. Thank you.
Thank you.
All right, let's go back to Cameron Miller and Taylor Young. I see Mr. Miller. Can you unmute yourself, Mr. Miller? Oh, there you go. Good. And Ms. Young is here and Mr. Camisa is here. And Mr. Camisa, did you see the declaration by Chandra Muncy?
No, Your Honor, I haven't seen it.
Ms. Taylor, did you get a copy of it?
Of the what? What did I get a copy of?
The declaration by Chandra Muncy.
No, I did not get that.
Okay. All right, well, she gave her impressions of the visit that occurred recently. So I wanted this hearing to check in on how that visit went and to decide how we're going to move forward in the future. I think what I need to do is read you portions of this. I don't want comments about it when I read it, because you may react to it, but I want to make sure we all have the same information.
Okay.
So starting at where there's a meeting at GC's truck stop, she writes, at that time, Rhonda came outside and also asked if Malaya was ready to go, insinuating that we would get into her car at that time. I also let Rhonda know that was not the plan and that Malaya and I would be in my car following them to the destination. Rhonda immediately got hostile and started saying that I was not right and that this was BS. I told Taylor to call her attorney, and then I repeated myself to Rhonda that I had a copy of the paperwork and that Malaya was not going to be getting in the car. Then apparently Malaya stayed with Ms. Muncy, and Taylor drove with her mom. They went up to Centralia. They saw some people. I think they went to the Children's Museum, or they were planning on doing that. I guess they did go to Applebee's in Olympia. And then she shares some of her thoughts that I'll read. Moving forward, I would not mind subbing for the visits. And that is because the initial supervisor was to be Cassie Salisbury, but she was ill. So I appreciate the parties working to find a substitute. I want to say that. She writes, everyone was respectful after the initial meeting. However, I do believe that there needs to be better guidelines for these visits. It was a very long day for everyone involved, and it was very overwhelming for the amount of people included. I would also like to see Taylor take control of the visits and not allow other adults to run the show or be in charge. I understand maintaining relationships are important, but I don't believe the most important relationship was the sole focus of this visit being between Taylor and Malaya. It felt like Taylor was more of a buddy and kept giving Malaya whatever she wanted to keep visitation successful. I definitely believe a visit strictly between Taylor and Malaya needs to happen to encourage the relationship and possibly have one or two locations, maybe being the apartment or a park, where there can be one-on-one time between them and establish some form of connectedness to try to keep a routine schedule. So that was her thoughts on that. I guess, well, Mr. Camisa, I'd be interested in your client's view of that visit. If you want to let her talk, or you can talk for her.
I can respond briefly. You know, speaking to Ms. Young, her main focus has always been the child and continues to be the child. She has submitted her fee to the guardian ad litem and is hoping for an independent opinion to remove these supervised visits. As even seen in the declaration, it continues to be tumultuous, the visits. You know, we're on our third or fourth supervisor now. If the current supervisor feels that she's unable to do it, I would just bring up again that Ms. Young's family members are able to do these supervised visits with no issues. If the court is still not inclined to remove the supervised visit requirements altogether.
Thank you. Mr. Miller, any response?
No, I don't got nothing really to say, except for it wouldn't be her family members. I'd want it to be one of those facilities. That's about it.
Ms. Corey?
Hi. So I have spoken with both parents as well as Malaya, and reviewed the records. I am fairly satisfied that the supervised visits probably aren't necessary. The last contact Ms. Taylor had with Mr. Stewart was in February. He has moved on, has a new girlfriend. She has him blocked on social media and also has a restraining order out against him. I would recommend and ask that Ms. Taylor contact the local domestic violence shelter for assistance in creating a safety plan for herself and Malaya. And based on the history of this case, going back to 2016 when it was a case in Thurston County, they had a guardian ad litem at that point, and one of the recommendations was that that Mr. Miller get a domestic violence evaluation, which I don't believe has happened. I would actually like to see both parties get a domestic violence evaluation and follow any recommendations of that evaluation. And I would prefer that that be with Ms. Lovely here in Kelso, if possible. I have received, as Mr. Camisa said, payment from Ms. Young. I have not yet received payment from Mr. Miller.
And I think Mr. Miller indicated he was going to make payment.
Yeah, I'm getting around to it. Okay, so the other thing, actually, I have a domestic violence impact panel already.
What do you mean by that?
I have the certificate for it and everything. I just have to go submit it.
So you've been evaluated already?
Yeah.
Well, provide that to Ms. Corey.
What year was that, Mr. Miller?
Two 2017.
What's your thought on that, Ms. Corey?
Well, that's getting on about 6 years old. And also, one second here, I'm sorry. So one of the questions in oh, I'm sorry, I was ahead of myself. Yeah, so was that evaluation done here locally, Mr. Miller?
No.
Where was it done?
Thurston County.
Thurston County. And did it recommend treatment of any sort?
No.
Okay. Yeah, I actually would like to see that. That would be a good start.
All right.
All right, anybody else want to say anything before I indicate how we're going to move forward?
No.
All right. Thank you, everyone. All right, I want one additional supervised visit, and I want some feedback from it. So I understand what Ms. Corey's saying. There were some issues that caused me concern in the declaration that was recently filed. And I want to do something to just address those. Okay, so let me lay out what I'd like to see. So I'd like the next visit to be on June 17th, which is a Saturday. I'd like it supervised by Cassie Salisbury, who we had agreed to earlier. I would like Taylor Young to attend that visit alone with just Ms. Salisbury. I would like you to meet at GC's truck stop at 10. During this visit, I don't want any other relatives involved. I want it just Taylor and Malaya. And once you get to the truck stop, then my expectation is Taylor would get into the vehicle with Cassie Salisbury, and you will go wherever Taylor would like to go. Taylor, you can plan the whole day. I would like this visit to end at 4 p.m. rather than 6. I'm assuming that that time is going to go well. And then We'll come back here on June 22nd. By that time, the domestic violence evaluation that Mr. Miller had should be reviewed by Ms. Corey, and I'll make decisions regarding any additional domestic violence evaluations. And I'll make a decision regarding unsupervised visits at that time. Okay.
Commissioner?
Yeah.
Go ahead.
This is set for a final review of my report on June 29th. Can we push that out some so that we can take a look at that domestic violence report, see how the visit goes, et cetera? Can we push that out maybe 30 days?
So how come Miss Young isn't taking the domestic violence impact panel?
Well, she might have to.
I mean, yeah, she's got DVs on her record.
Well,
so
I'm gonna address that. The guardian ad litem is recommending that. I'm just not making a decision at this time. Okay, I'm wanting the guardian ad litem to review the material you have, Mr. Miller, and then I'll make a decision.
What happened last time?
Can we push that out to say July 20th?
We can strike the 29th. So first of all, I want to leave June 22nd because we may go to unsupervised visits after that time. And then we'll strike the 29th. And if you want to set that for July 20th, we can do that.
Perfect.
Your Honor.
Yes, Ms. Young.
Respectfully, I was wondering if we could change the supervisor, because on my part, I feel like we've been over this with Cameron's supervisors and they already have their opinion on me from them. And I feel like they're giving false feedback. And I really feel like if it was at my grandparents, I would have one-on-one time. And those in the supervised visits, I really feel should not be there because
your grandparents aren't doing it.
Mr. Miller, don't respond. This is directed to me.
And I've been every single time I've been doing it his way since the beginning. I've done everything that he's wanted. And I will do a visit at the place, but the supervisor plays anything, but I really feel like I don't need supervised visits. I can have one-on-one time with my child at my grandparents. And that's a safe, neutral environment for both of us, because I feel Cameron's having people who already have an opinion on me. And
they don't even know you, Taylor.
Point.
Mr. Miller, please.
I'm not gonna wait to talk about this anymore.
All right.
I will do visits at the supervised center though, but I don't feel like his supervisor. I don't want his supervisor because.
So time out. I'm gonna interrupt you. So whoever is talking behind you, Taylor, you need to talk for yourself instead of having somebody whisper into your ear.
Mr. Miller.
We can all hear it.
Your Honor, I just believe that there should not be supervised visits. This has been like a year now, and I feel like I'm not getting anywhere.
Your words or somebody else's words?
The relationship between me and my child, because they're saying whatever they need to say. They have these people coming saying whatever they need to say because, for example, they said there was a lot of people at the visit. My grandparents, my mom and my aunt and my grandma came to the Children's Museum to watch her play and stuff while I had time with her. I don't see why that was a problem. But if it needs to just be me and her, I can have it just be me and her. But I feel like his supervisors don't need to be there.
They're going to.
All right.
Commissioner?
Yes, go ahead.
I'm so sorry, if I may. I also do have some concerns that the last supervisor was paid by Mr. Miller.
No. Oh. I paid for her birthday dinner.
I believe it stated that you gave her $100 for gas and things.
So I'm in trouble because I pay her way to go up there.
Go ahead, Ms. Corey.
That's just a concern that that the supervisor then feels perhaps some
No.
That she owes Mr. Miller something. And I would prefer that this go to a professional supervisor to get that really less biased opinion about the visit, if that's possible, to do just a single visit. I know it does take some time to set up.
Well, that's going to push things out for Ms. Young farther than I think she wants, and probably farther than I want. The last time we were here, we agreed that Cassie Salisbury could be the supervisor. That got changed. Honestly, the Chandra Muncie declaration, I thought was a very factual declaration, and I didn't see that it was, I didn't read into it that it was biased one way or the other.
Well, I had 100% one-on-one contact with her. There was no me separating from her or me being her pal. And she stated that I gave her whatever she wanted. I got her ice cream and lunch. She's my kid and I haven't seen her in a month and a half. I don't see whatever I spend my money on my kid or what she wants, that has to do with me. And I don't understand what she was meaning. I gave her whatever she wanted to make her, they're sitting here making it seem like I don't have a relationship with my kid, that I don't do this, and that is not the fact. Every single time I ask her what she wants to do, we hang out all day, and it's uncomfortable when someone's following me to the bathroom, when someone's 2 centimeters away from me, saying, I need to be in ear range and know everything. You don't need to follow me to the bathroom. That's what you don't need to do. You're taking this too far. And it's getting ridiculous because it's getting to the point where they're forgetting that I am her mother at the end of the day. I would do anything for her. And these supervised visits is just crazy because Cameron has a whole list of things he has done and put me through and all this, and everyone's just bypassing it like he's this #1 dad of the year. And he's not.
No, we're not, Taylor. Okay. And everything that is going on, you've done to yourself to take accountability for that.
Mr. Miller, just let Ms. Taylor speak.
I just really believe if I have to do visits that they should be at my grandparents unsupervised. It would just be me and her, and that is a mutual play for all of us. And he knows that.
I'm not going to change my decision. I want to get feedback from one additional supervised visit, see how it goes.
And are these the same people who wrote statements about me and declarations? Because I'm pretty sure she wrote a statement as well.
Well.
And like he said, they don't even know me.
Well, again, we had discussed Cassie Salisbury a couple weeks ago. She was acceptable then. And we're probably moving to get to unsupervised visits. I just want one more supervised visit with just you and Malaya. And I want that to occur on June 17th. And hopefully that will go great. And then we can discuss what we do going forward on the 22nd. So I'm not changing my decision on that. 17th at GC's truck stop from 10 to 4. Okay. All right, thank you. We'll see you back here on the 22nd. Miss Young was here. There we are. Miss Young, there we go. Okay. So I read the declaration and it looked like the visit went pretty well last weekend. Miss Young, what was your impression?
It was nice. We went to the movie and I got some one-on-one time with her. We went to the park. And again, it was good. I just feel like we could still do the same thing, just us. It went well. It was definitely, she was nice.
All right. Mr. Miller, any comments?
Yeah, actually I do. So
Okay.
I've been under the impression from like my girlfriend and Taylor and my girlfriend have been talking that Taylor wants to just settle this. She wants to just get along with the parenting plan. That's my impression. Yeah, I'm under the impression that Taylor was going to bring it up in court today, but I just beat her to the punch, I think.
What's your position on that?
Mine is
No. I'm talking to Mr. Miller right now.
Okay. What do you mean? Like,
I mean,
like, how do I think on that?
Well, there's a temporary parenting plan that calls for unsupervised visits basically every other weekend. That's an order that was in effect until we changed it, because I think it was Drew Stewart came into the picture and he had some issues, and we wanted to make sure that your daughter wasn't in contact with him.
Yeah.
My understanding, he's out of the picture at this time.
Completely.
So, what's your position on unsupervised visits every other weekend, Mr. Miller?
I don't have an issue with it.
Okay. All right. Ms. Young, what's your position on that?
But time out, please. I do want to like make it clear though, we're all on the same page that my daughter comes home. That's all I ask. That she comes home, she's back here for school. That's it.
And I proposed something else too, but you guys haven't responded to it. And I'm waiting for my attorney as well.
So tell me what's your position on the if we re-implemented the current temporary parenting plan?
Well, he wanted to be every other weekend during the summer, every other week during the summer, and every other weekend during the school year. But I wanted it to be, we just switch it. I get her for the whole summer. He gets her every other weekend. And then I get her on the weekends during the school year. I feel like that's the only way fair. If not, I feel like she belongs to be with me 5 days a week, because this every other weekend, I don't feel like that's another 2 weeks going without seeing her. So I said, if you guys really don't want to move her in school, then she lives with me for the breaks and for the entire summer. That's 3 months out of the year that she can live with me.
I can't allow Malaya to go all summer.
Mr. Miller, let's just listen.
Okay.
Right now.
And she would still get every other weekend. That'd be the same thing as 9 months of the year when she's in school, that I'd have to see her every other weekend. So why can't I have her during the summer? Because the big thing was that she's in school. Well, when she's not in school, she should be able to be with me. I've had her for 5 years of her life. This just started. And the only reason she hasn't been with me is because Cameron was keeping her from me.
We're not going to go down that road, because that's not what we're even talking about. We're not going tit for tat. We're trying to settle it, Taylor.
I'm not going tit for tat at all. I'm just stating that if you want her for the school year, I feel like I should get her for the summer.
Okay, I need both of you to listen now. I'm going to ask Ms. Corey to weigh in on this.
I don't think we're near finding a final solution. I think going back to the previous temporary parenting plan is a good call. Obviously, this investigation needs to be completed before we can find some common ground. As of yet, Mr. Miller has actually, we have had a Zoom appointment, and that's all. I have not received payment from him as of yet, going on a couple of months now. So, but I'm
not making no payment until everything's done. That's how I work. When the job's completed, that's when I pay. It's no different than running a business. When the job's completed is when payment is received.
The problem with that is if you don't like the conclusion at the end of the job, then you can walk away and not pay. And that leaves guardian ad litems vulnerable. So they need to be paid as we go along.
Well, if me and Taylor figure it out, then she was actually brought in for no reason.
Well, obviously, we didn't figure it out.
Well, we
haven't even really talked about it yet, Taylor, have we?
All right. No speaking right now. I want to find Just a moment here. All right, I encourage the parties to reach a resolution, but for right now, I'm looking at the temporary parenting plan, and it calls for every other weekend from Friday at 6 to Sunday at 6. And it calls for the drop off and pickup location at GC's truck stop. And what I want to do is,
can we move it a little closer? Because I drive like almost an hour and they drive 15 minutes.
Not 15 minutes to GC's truck stop.
Here's what I'm looking at is, rather than make changes, what I want to do is implement what the court already decided. And then I'm going to tell you what the potential next step is, okay? So Ms. Young saw Malaya on the 17th. If we go every other weekend, that means it's July 1st or June 30th, and July 1st and 2nd would be the next weekend.
I talked them, I do have a family reunion from the 27th to the 3rd that I wanted to take her to.
Well, you'll have her there part of that time.
Because it's in Spokane. But I'd love her to meet that side of the family.
Again, right now, I'm going to stick with the temporary parenting plan that was in effect, that was entered on September 22nd, 2022. So it's going to be Friday at 6 to Sunday at 6. If you and Mr. Miller can come to an agreement as to what would be a final parenting plan, then I encourage you to do that. Otherwise, I think your next step is to set this for a trial regarding a permanent parenting plan. And you would have to put that on what's called the Universal Trial Setting Calendar, which is on Wednesday at 1 p.m. And then if you can't come to an agreement, you can each present your case as to what parenting plan should be. That's at that time, Ms. Young, you can explain to the court that you'd like Malaya all summer if she's going to stay with Mr. Miller all winter or all school year. So that's where you would make that argument, okay?
Your Honor, if I was to accept like her offer for her having Malaya all summer, would I not see Malaya at all summer?
I think it would essentially switch. You would have to see her every other weekend.
Okay.
But so then we communicate.
What I hear her saying is during the school year, she would get every other weekend. During the summer, you would get every other weekend. Okay. That would be the proposal.
And then we have breaks. We split them like Christmas. We split them.
Sure, you'd have to figure out spring break, Christmas break, and other holidays, how you're going to handle that. You'd have to handle, if Mr. Miller wanted to spend a week on a vacation with Malaya during the summer, you might have to factor that in.
Okay.
So at this point, I'm implementing the temporary parenting plan, unsupervised visits, Friday at 6 to Sunday at 6. And I encourage you to work together if you can and come up with a plan going forward. You can both sign off on it and send it to me and I'll sign off on it. Or
is the training order listed to where I can actually talk to her, or do I still only have scheduled visits?
Let me see if there's a note here about that. Do you have any objection to a telephone call, Mr. Miller?
No, Your Honor.
Okay. Let's limit it to once a week. So that would be 2 calls in between your visits for right now. And then again, you and Mr. Miller can speak, and I hope you come up with an agreement. Okay.
Yes, Your Honor.
Ms. Corey, anything you'd like to add?
It seems like my services aren't wanted in this case. May I be excused?
Yes, at this point you can. Mr. Miller, you're still required to pay Ms. Corey for the time that she put in.
If she don't mind.
What's that?
I still want her in it. My attorney hasn't responded to me or anything. I have no idea what's going on.
All right. I don't know that I was going to set another review hearing here, because I think either you're going to come to an agreement or you need to set it for a trial.
But if Twyla doesn't mind, I'd still like to have a conversation with her.
Ms. Corey?
I don't mind staying on the case, but I would like to be paid for my time.
Yeah.
And the court's policy, as well as my policy, is that I be paid ahead of time, and I hold that money. If there is any left over after completing the job, then that would be refunded to Mr. Miller.
Okay.
To Miller or me? Because since Miller didn't pay.
To both.
Oh, okay.
All right, I'll set a review. I'm going to set this out of ways. I'll set a review for July 27th. And that will be to look at the status of payment. The court has the ability of entering a judgment against one party or the other if there's no payment. And I may consider that at that time.
Yep.
Okay.
What was the review date again? I'm sorry.
You bet. July 27th. That's a Thursday at 9 o'clock.
Okay.
Okay. I hope you can come to an agreement. Okay. Thank you.
Next, I have Cameron Miller and Taylor Young. This is cause number 223003698. I have Ms. Corey. Do I have Cameron Miller or Taylor Young? All right. So Ms. Corey, this matter had come before the court on an issue of fees and review. Why don't you give me an update on what's happening?
Well, I'm about 10 hours in and have not yet received payment from Mr. Miller. I have received payment from Ms. Young. They indicated to me recently that they have come to an agreement on the parenting plan. And I'm just wondering what to do now. I have one small issue with their parenting plan that hopefully can be worked out between them. But I don't know what to do. I need the court's input here.
Fair enough. So let's do this because it sounds like there's a potential agreement. Mm-hmm. Why don't we put the matter over, because it's already set for review. Why don't we put it out 3 more weeks to August 17th? That gives you an opportunity to see if they can resolve that issue, have a proposed order, and ideally appear on the docket. We can address the order if there's an agreement, and we can also address payment. And I would be clear to Mr. Miller that he is obligated to pay your fee, and the court can consider a judgment or other relief potentially if he fails to pay that.
Okay.
All right. So over to the 17th, and hopefully fees are paid and we have an agreed order by that time.
Thank you.
Thank you. All right. Next, I have the Miller and Young matter. This is 22-300-36908. All right, and I have Ms. Corey, this matter on to review payment status.
I have had a really difficult time getting in touch with both parties. They apparently have come to an agreement and have not yet filed that with the court. And Mr. Miller has not yet paid me.
Okay. So one party is paid, but not the other. Is that fair?
Yes. Ms. Young gave me a retainer of $1,600. At this point, I am, if the invoice I have has about 10 and a half hours on it for $1,575. So if Mr. Miller were to pay me the $787.50, half of the $1,575, I could refund some of that to Ms. Young. But
here's what I'm going to do. At this point, I'm going to go ahead and release you from service on this case. If the parties don't want, if the parties are not motivated to continue with your services, I don't want you to have to keep showing up to hearings like this and sort of spinning your wheels. So I authorize you to go ahead and just not issue a final report, but just issue essentially a non-compliance, that the parties aren't complying with you, that this is your final invoice, and that the court authorizes that you to pay yourself out of what's been paid so far. And if the parties have disputes about who should have paid what, they'll need to bring that back to the court.
Okay.
That sort of puts the ball back in their court.
Okay. So is that a actual document I need to file?
My preference would be that you like treat it like a GAL report, as far as like the caption and the like, but like essentially a cover sheet. And you can even just do it as a letter. That way, if it's a different judicial officer, they'll understand what happened. So okay. Just that the court's authorized you to withdraw. This is the invoice at this point, and that if there's any disputes, the parties will, regarding payment, and then the parties will need to bring that back before the court.
Okay, thank you.
All right, thank you for being here.
Next, I have the matter of Cameron Miller and Taylor Young. This is cause number 22-3-36908. I'll ask Cameron Miller is on the line. Cameron Miller. Right, not hearing a response from Cameron Miller. I'll ask if Taylor Young is on the line. Taylor Young. No response there. I see Miss Corey is on the line. And I'll just, once again, Cameron Miller, if you're on the line, make sure you're unmuted and state your name. I'm not hearing any. Go ahead.
Mr. Miller is currently incarcerated in Lewis County. He was properly served on March 12th at Cowlitz County Jail.
And did you verify?
I verified that he is still on the jail roster this morning.
Any indication as far as release date, if he's pre-trial or post conviction?
I don't know.
Okay. So do you have any? So I read over your motion, and I'm not I understand what you're asking for. You're asking that for a contempt finding, that for willful failure to pay without him being present. He has been served and he hasn't filed anything in response. What is your position as far as moving forward today?
I don't know.
That's a fair answer. That's okay. It sounds like he was served March 12th at the Cowlitz County Jail, and then he's now at the Lewis County Jail. And I'm not exactly sure what happened there. Sometimes people may resolve a matter here, and then there's a holdout of another county, and they get transferred immediately there. Pretty difficult to file a response, not impossible to file a response from jail, but it is a little more challenging depending on the level of paper and access to the internet and like that one may or may not have. This has been a long-standing issue that goes back many, many months, if not close to a year. Not knowing the length of his incarceration, I think what I'd like to do is just give it one more week. Let's set it over one more week. And Miss Corey, if you could alert me at the beginning of next week's docket, because sometimes there's a lot swirling around as I begin a docket.
I am actually out of town next week.
Okay. Maybe would you be averse if we were set it over to the 10th of April?
The 10th would work.
And if you could remind me on that date that your matter's fairly short, and we could call it first, and so you don't have to be on the line as long.
Okay. How do I need to notify him then of that new date? And
that would be appreciated. I mean, that would give the court more confidence of moving forward if he has been given notice of the hearing on that particular date. Then he could make arrangements with the Lewis County jail officials to get them present via Zoom.
Would I have to actually serve something on him? The reason I ask is because before he was in Cowlitz County incarcerated, he was in Lewis County the first time, and then before that he was in Thurston County, and then a tribal jail. So he's been incarcerated for quite some time, and most of those places actually charge you $60-$70 to serve.
Do you know if I'm assuming that somebody who's incarcerated can receive mail and receive a docket notice?
Oh, good idea.
Maybe that would be one approach. To at least he's given notice, and then he can make arrangements with the county jail folks, and with the 2-week time frame, that should be adequate.
Okay, thank you.
All right, we'll be back on April 10th. First, I'm gonna hear the first matter I'm calling is the Miller and Young matter. This is a moment. This is cause number 223-36908. I'll just double check to make sure everybody's present. Cameron Miller, are you here? Let's see, Cameron Miller, if you're here, make sure that you're unmuted and state your name so I know you're here. Okay, no response from Cameron Miller. Is Taylor Young present? Taylor Young? Okay, just again, Cameron Miller or Taylor Young, if you're on the line this morning, please unmute. If you're dialing in using a phone number, you can press *6. That will mute and unmute alternately. And if not, otherwise, just use your device or your computer and click on the icon that looks like a microphone. Cameron Miller and Taylor Young.
Your Honor.
Yes.
I actually brought this matter, and Mr. Miller was incarcerated when I initially served him. He did not appear the initial, I believe it was 2 weeks ago. And since that time, he has been released, and I have not been able to serve him with the new date.
Okay. All right. Thank you for that update. What is your preference, Ms. Corey, as far as, would you like to have it just be stricken today and you could renote it once service has been effectuated?
I have great doubt that I am going to be able to serve him. Okay. So I don't wish to renote it at this time.
Okay. And are you withdrawing the motion, or are you asking that it proceed?
If I am able to serve him in the future, I'd like to be able to proceed.
Okay. Yeah, I think that's fine. At this point, we'll just strike the hearing for today, but the motion can remain pending. It can be renoted at a future date.
Okay.
All right. Very good. Thank you.
Thank you.
Next, I'd like to call the Florek matter. This is cause Next matter I have is Cameron Miller and Taylor Young, cause numbers, pardon me, just a single cause number 223-36908. I'll ask if Cameron Miller's on the line.
I'm right here, Your Honor.
Okay, welcome to you, Mr. Miller. And Taylor Young, are you on the line?
Hi.
Okay. Welcome to you, Ms. Young. All right, so let me just pull up my notes. And Ms. Corey, are you associated with this case also?
I was associated with the case. I was released from it when Mr. Miller did not want to cooperate. But Ms. Young has stayed in touch with me and has kept me in the loop. I've also received other information on this case, and so I chose to be here for this today.
Okay. All right.
And I do have information to
okay. All right.
offer to the court.
Very good. Thank you. All right. We're here today on Mr. Miller's motion for contempt and a motion for a restraining order. Before we get started on that, I just want to make sure that I'm clear on the service issue. So the restraining order that was issued on April 13th, I wanted to just touch base with Mr. Miller to make sure that that document was served upon Ms. Young. I saw that there was a picture taken of a document stuck in kind of between the door and the door jamb, and that was done by Jim and Danita Bartley. So can you help me understand a little bit more about the service of the restraining order on Ms. Young?
So I've had Centralia police officers try to go to that address. They couldn't make contact with her, and that's Taylor's last known address. She has taken my daughter out of school district, out of Jefferson Lincoln, enrolled her into elementary. Malaya, my daughter, has an address up in Spanaway that I've had Pierce County deputies try to make contact with her. She's kept my daughter out of school now for a week and a half after she found out that I had found her.
So let me touch base, just kind of going back again to the service issue. That's kind of my focus right now. That's kind of the first hurdle we need to talk about, and then we can go into the meat of the
Yeah, nobody wanted to come to the door, so they seen that the person was trying to serve them, so I stuck it in the door, took a picture of it, and I submitted the proof of service that way.
Okay.
Because Taylor's been running from the police and everything. Everybody's, been trying to find her.
Okay. So it says, okay, so I'm looking at the proof of service. It says, my name's Sarah Amber Damasio. I served the court documents to Taylor Young by giving the documents to Jim and Danita Bartley, a person of suitable age and discretion who lives at the same address as Ms. Young. And that's the one Correct. Up in Centralia?
Correct.
Okay. And so how do you know that Ms. Young was living there with the Bartleys?
It's her last known address, and it's her grandparents.
Oh, so that's the grandparents' address?
Yeah, and that's what's on her ID as well.
Okay. All right. And it looks like what was served was a copy of the restraint order and a hearing notice. Is that correct?
Correct.
Okay. All right. Okay. All right. And so let me touch base with Ms. Young. Ms. Young, did you get a copy of the immediate restraining order?
I did not get a copy. I haven't seen the copy, but when I found out about it, I did contact the court. I did take her out of school because he started harassing and under the circumstances, I did not feel comfortable giving her to him. He was just in jail for 4 months.
So I want to just focus on, let's see, we're getting feedback from somebody here. I just want to focus on the service issue first. So it sounds like you were made aware of today's hearing. How were you made aware of the hearing today?
I called because the school contacted me that Cameron was, and then I found out there was a school resource officer who I tried contacting back because they left a card. I wasn't there. And I tried calling back and she wasn't in or available or in at the moment. And then that's when I contacted the courts because I tried filing myself. And like I said, I kept in contact with my attorney. They told me that there was court on the 8th. And so I spoke to her and she said, if I'm not served, at least just show up to the court date on the 8th.
So it looks like you also filed a declaration on the issue of contempt. Is that correct?
Yes, but that has not gone to him because I don't know his address. But I could give him copies via email or something, but I do not know his address.
Okay. It also looks like you filed some other reports related to some other copies of documents from a different court. It looks like the Lewis County matter.
Yes, and that's
Thurston. Sorry.
And that's when I was saying not contempt because he was in jail for months. I tried getting in contact. I found out his sister had her. He was in jail. She put him in Jefferson Lincoln. When I found that out, I went to go get her.
So,
and
I apologize for interrupting. Just I'm still focused on the service issue. And so we're still not to the meat of the issue. So I guess the concerns that I have at this point is that service is required in all cases. Here we have Mr. Miller, who's indicated that an individual gave documents to, sounds like your parents up in Centralia. And then you filed a response to the motion for contempt. And then that response, I don't think, Mr. Miller, have you seen that response from Ms. Young?
No, I haven't gotten it. And her not knowing my address, that's false information because it's in all of the court case. It's in all of the courthouses.
Okay. So let me ask, Ms. Young, the address that you filed as on your pleadings is the Centralia address, and is it Warren Street? Is that what it is?
Wanch, that is on my ID, yes.
Okay, Wanch.
I use that as my mailing address.
Okay, that's the address where you can be served with documents, is that correct?
No, that's just where I get my mail.
So that's the address where you can be served with documents, correct? If somebody were to mail documents to that address, you'd get them?
Yes, I could get them, yes.
Okay. And then Mr. Miller submitted, I believe he has an address in Rochester.
Correct.
And that's where you can receive documents, correct, Mr. Miller?
Correct.
Okay. So I think I'm not necessarily satisfied with the service issue. What I think needs to happen is that, number one, I think the documents that Mr. Miller submitted or gave or provided to the Wanch Street address to the Bartleys by virtue of his process server, pardon me. I think that suffices. I think that's fine. So I think there's good service on Ms. Young related to that. Ms. Young, you filed a bunch of documents that Mr. Miller has not seen. He needs to see those to be able to respond. So what's happening here is that Mr. Miller is asking for a contempt finding related to the spring break. Correct, Mr. Miller? That's your motion?
Correct.
Okay. So what I'd like to do is make sure all parties have in their possession and are able to review what the other party has submitted and stated. So that means Ms. Young, you'll need to submit your documents and file or send copies of them to Mr. Miller at his Rochester address, and you can use the US mail. And then once he has those, if he wants to reply to those by submitting something, then he's free to do so. So you would need to send those out no later than this Friday to that address. So you would have them probably 2-3 days of mail, and then he'd have an opportunity to respond. So what I'm proposing is continuing the matter to May 22nd, which is a Wednesday morning at 9 a.m. So everybody can see what everybody else is saying and then discuss the issue. Any questions on that proposal?
Can she continue school?
So with that, so since you approved with me filing the motion and she did get the information with the restraining order, when do I pick up my child?
Your Honor, I would like to say she's still in school. And
she's not. I've called the school.
He was in jail
Let
for
me
the last
finish,
4 months.
So for me on the receiving end of Zoom call, when there's crosstalk, I can't hear either of you. So the simple rule we use is that one party speaks. So at this point, the motion for contempt relates to the spring break. It sounds like there's other issues about the parenting plan and the like, that if it's not being followed, then an additional motion for contempt could be filed. It sounds like there's concerns related to the child being moved to a different address or to a different school, which may be the source of a motion for contempt. So So in response to Mr. Miller's comment / question about, kind of next steps about when do I get to see my child, my understanding is that there's a parenting plan in place and that a parenting plan has not been modified. So therefore that needs to be followed. And that's the expectation of the court. So go ahead, Ms. Young.
And there in the parenting plan, it states that they are in Longview. If you read the parenting plan, you're not supposed to move the child's schools. You're not supposed to introduce your child to a significant other after 4 to 6 months. I have on the 29th of March, because he was in jail, I got from Lewis County courts, they wrote an order that I got her back. They put her in Centralia. I don't live in Centralia. I won her back from his sister because he was in jail, and I put her in school where I lived. I didn't know when Cameron was going to come out. I didn't know what was going to go on next. He still has court dates. I don't know what's going to happen for the future. But when I had her, I did what I was supposed to do. I put her in school. She's already started baseball. She's starting to get on a routine. And I want to keep it that way. If he wants weekends, if that would work, because he works from the morning until 6 o'clock at night.
Ms. Young, do you mind just chime in here? So the question is related to the parenting plan. There's a parenting plan in place as of September 1st, 2023. Mm-hmm. That parenting plan controls, and it's expected that everybody's following that order. So it indicates that Mr. Miller is the custodial parent and that Ms. Young, you have time with the child on every weekend except the first weekend of every month, starting from Friday at 3:30 until Sunday at 6 p.m. So that's the current order. And also the order says there's to be no relocation without agreement or permission of the court.
I didn't have.
So the parenting plan is in effect. The parties are expected to follow that parenting plan at this point. So my proposal is to come back to talk about the contempt issue about spring break when we come back on the 22nd of May. And both parties are going to share information, make sure that you have each other's pleadings. If there's other concerns related to the parenting plan, either party is free to file a motion for contempt related to that.
Your Honor, so what do we do about school? Can he make sure she continues to get to school? She does not want to go to. She was bullied. He would know this if he would communicate with me. She loves her new school.
So the parenting plan talks about decision-making. The decision-making indicates the following. For school and educational, it would be joint decision-making between the parties.
And he was in jail for the last 4 months. So how was I supposed to communicate with him or anything when he was in jail?
Let's say something now.
So, Ms. Young, the issue before me is the issue of contempt, and then the follow-up question is related to what do we do now? There's a parenting plan in place that controls. If the parties have questions of what you need to do, you refer to the parenting plan. I'm not going to look retrospectively about what was to happen during the 4 months of incarceration. I recognize that poses a bunch of difficulties, but the issue that we're focused on is the contempt. We'll talk about that on the 22nd after documents have been exchanged, and the parenting plan that was issued in September of 2023 controls. And if parties have questions, check with that. Mr. Miller.
So with the restraining order that restrains Taylor from Malaya and to put Malaya back into my custody, since Taylor is aware of it, correct, I should be getting my daughter back today because now she is in violation of the restraining order.
Ms. Young, there's an order that was filed on April 11th. It's a temporary restraining order in order to show cause. And you're here today on that notice, and it indicates that the, just a moment.
She's gonna freak out.
It indicates until the hearing that the child is to be with Mr. Miller. So that's the order of the court that indicates at that time, that order says that the child is to be returned to Mr. Miller.
So can I ask Mr. Miller what you're going to do about her school? There's a month and a half left.
So I'll allow the parties to discuss things separately amongst themselves. the order is what the order is, and we'll be back here on May 22nd. Again, the expectation is that if there's a court order, such as an immediate restraining order that requires the child to go back to Mr. Miller, then the child needs to go back to Mr. Miller. And then the other idea is that the parenting plan is in effect. So those two documents control at this point. And if there's not compliance, then we'll certainly hear about that on May 22nd. The court will take appropriate action.
Your Honor, where today can I meet Miss Young or her mother to pick up the child?
Any suggestions, Miss Young?
I would rather it be in a public place.
Okay.
Fine with me.
Suggestion.
So can I speak real quick? I do work in Tacoma and I do work in the Spanaway area all the time. So if she wants to meet at the school this afternoon, I don't mind Miss Young spending. No, I can meet her at the school here in about 30 minutes. I'm on my way up there right now.
I'm not in Tacoma at the moment.
Where are you?
My thinking is tomorrow would be give a bit of a buffer and a bit of a transition period for the child. So let's plan for the exchange to occur tomorrow.
I need to prepare her for it.
I need to know where Miss Young's located so I can have an idea where to meet at a public place.
Can we meet at the Centralia Safeway?
Sure can.
Okay. Is there a time that would work better for you, Ms. Young?
Well, for me, it would be in the morning because then I can get Malaya back to her school on my way to work.
Okay.
So
Ms. Young?
Yes.
So Mr. Miller's proposing tomorrow, the 9th of May for an exchange time in the morning. I think he said 8 a.m. Okay. What do you think about that?
That's a little early. I'll just
how about I can do 10:30 or 11.
That'll work.
Okay, let's set the time at 11 for the exchange to occur. And then both parties.
He returns her to me on Friday.
Whatever the parenting plan is.
Yeah, that's the parenting plan. I do get her back on Friday.
There's a restraining order that restrains Malaya from you until the court.
That's a good point. I apologize. Mr. Miller raises a good point. There's a current restraining order in place that
can you revoke it?
It can certainly be modified. It's certainly be modified. And I think what we're going to do when we come back on the 22nd, we'll need to talk a little bit more about it at that time.
So I can't see her till the 22nd. Can you keep her in her sports? Can you at least make sure she gets to baseball, please, for me?
There's a lot of difficulties that and issues that we're encountering at this point that, we're here on two issues. One is the contempt we're going to talk about on the 22nd, and on the restraining order. The restraining order is in place, and that Mr. Miller's right with that restraint. It's going to be in place until the 22nd, until we come back and figure out a little more clearly what's happening. So the parties have opportunity to speak, and that certainly causes difficulties for everybody, especially the child. So with the exchange set for tomorrow, the parties have agreed on that May 9th at, I think 11 o'clock was the time. And then we'll be back here on the 22nd to figure out next steps.
The 22nd of May?
22nd of May. And the location of the exchange was where?
Centralia Safeway.
Centralia Safeway. Okay. All right. We'll be back here on the 22nd. Thank you.
Twyla still have something to say.
Thank you, Your Honor.
I think she probably looks like she opened her mouth, so she probably has something to say. Go ahead, Ms. Corey.
I did have something to say, but since you have made your decision, I will.
I'm open to revisit it.
Okay. So this child has actually been in 3 schools since over the course of the school year. She was enrolled initially at Mint Valley Elementary when I was involved in the case. And in November, Mr. Miller's girlfriend and son were killed in a tragic accident. She did not return to Mint Valley after that, November 10th, 2023. She then apparently bounced around a little bit and ended up in Raymond with Ms. Denny's mother, who told me that she had her in her care at the request of Mr. Miller. She didn't know where Mr. Miller was at that point. She enrolled her unofficially in a private Christian school in Raymond and put her in counseling without the parents' permission. And indicated to me at that time that she had planned to honor the parenting plan and give Miss Young her parenting time, which I don't believe happened after that. Then on the 19th, and Malaya was disenrolled from Mint Valley in December. In January, then her records were requested from Mint Valley in order for her to be enrolled in school in Centralia, which is the one I believe we're talking about. Then I learned from Ms. Young that Malaya had been withheld from her since before Christmas, and that Mr. Miller was in the Thurston County Jail, and I confirmed that. And around the same time, I learned that Mr. Miller's sister had Malaya and had filed in Lewis County for guardianship, which was eventually denied. In April of this year, I got an anonymous email stating that they were frightened for Malaya and that Mr. Miller is emotionally unstable and using narcotics. The email states that the sender is unable to provide specifics because of, they were frightened because of his emotional instability. She's now in the third school in 6 months, and I just hate to see her bounced back and forth yet again for the school year. While I was involved in this, Mr. Miller was extremely uncooperative. He told the commissioner in the case that he would not pay me. I've been following the case since because he still has failed to pay me. I served him with a notice of contempt hearing while he was in the Cowlitz County Jail. And then he was transferred to the Lewis County Jail, so did not attend that hearing. So I'd like to go ahead and I can serve him now by postal service since I have the address.
I have something to say. So yeah, I have no problem with payment. And I also have no problem taking a UA.
Okay.
Clean as a whistle.
I would ask for a hair follicle 17 panel to include Suboxone.
You don't need it. I can give you guys information to my counselor at not New Directions, but Cascade Mental Health, or my DOC office, or probation. Which one would you like?
So as far as Mr. Miller, you're indicating that you would be willing to submit it to a hair follicle test. Did I hear that?
If needed.
Sorry, could you repeat that?
If needed.
Okay. All right. I think that's, if you're comfortable doing that, I think that, that resolves any doubts. So if you're willing to do that, you'd need to submit to that and then submit sign a release of information, an ROI, and then supply that information to Ms. Corey and Ms. Young.
But what I don't understand is why I would need to do that if all I have to do is sign release information from Cascade Chemical Dependence, somewhere that I'm already taking UAs on a daily basis, or DOC that I'm taking a UA every Monday. So there would be no point for any of that.
Yeah,
if I was to sign release of information.
As you're probably aware, your analysis is kind of a shorter term and catches things in the moment or within a few days, and then the hair follicle goes back a number of weeks.
I have no problem with it.
Okay. If you don't have a problem with it, then I'll order that. And if you could take that and then supply that to the parties, that would be fantastic. So yeah, Ms. Corey's concern related to the movement of the child in different school districts is valid and very concerning. I agree, and yet we rely upon the parents to do their best to keep that stability, and hopefully that'll be in the forefront of all the parties' minds related to this. So
I have been in contact with school.
Okay, so I'm going to continue with what I indicated before. I appreciate the input from Ms. Corey. So
that'd be him considering moving her to a different school without my permission or talking with me, because his sister put her there, not him. But if he puts
I never once stated if I was taking Malaya out of the school or
so
putting
Mr.
her
Miller,
into a new.
Mr. Miller, Ms. Young was speaking and you spoke over her.
You just said that you were going to put her back in Centralia 5 minutes ago. She has a month and a half left and she likes her school. If we can make it work to where she can still go to school and play sports.
Ms. Young, there's the issues you're raising are super important. I have a room full of people still here. There's issues that need to be sorted out, and they're not going to be sorted out right now. And it has a pretty dramatic impact on the young lady. We will return on May 22nd at 9 o'clock in the morning. The exchange will occur tomorrow. The restraining order is in effect. We'll see everybody on the 22nd.
Thank you, Your Honor.
I'd like to have Carol Daniels and Sean Fields, 23-3-1.
Cameron Miller and Taylor Young.
Here, Your Honor.
Yeah.
And has the child been returned?
Yes.
And Ms. Young, it looks like you still haven't filed any sort of response. Is that right?
Yes, I did. I responded and I turned it into the courts and I served Cameron.
Let me look here. Oh, okay, there it is.
So, Your Honor.
Hang on just a second. Okay, so let me ask Mr. Miller, from your standpoint, are both parties now following the parenting
plan? As of what do you mean by that? Because as of right now, yeah, my daughter's with me with the restraining order that restrains Taylor from me. But the paperwork that Taylor served me with, I have no case numbers on anything. The only thing that I technically have.
Okay, Mr. Miller, I need you to listen to my question and answer my question. At this point, as far as you are concerned, are both parties following the parenting plan?
Yeah.
Okay. Ms. Young, from your standpoint right now, are both parties following the parenting?
No.
And in what respect?
There's a restraining order, so that keeps me from seeing her. And before he got the restraining order and all of this, he refused to let me have her. He kept her from me.
Ma'am, I need you to listen to my question and answer my question. As of right now, are both parties following the parenting?
Yes.
Okay. Ms. Corey? Where are we?
So in the last hearing, Mr. Miller was directed by the court to get a hair follicle test. I do not see that has been filed, nor have I received it.
And Mr. Miller, what's going on with that?
So with that, for one, I don't know where to go get a hair follicle. And for two, I was talking to lawyers and they said that that's not technically fair because it goes back to 6 months when I'm already on. Okay.
Mr. Miller?
It goes back
Mr.
6
Miller.
months. Yeah.
You were here on the 8th.
Yes, I'm aware of that.
And the judge ordered you to get a hair follicle.
Where do you go get one?
If you can't figure that out, that causes me a lot of concern about your abilities as a parent.
I know where to go get a UA at.
Well, why don't you call them and ask them if they can do a hair follicle, if they can tell you where to go get it?
Okay, I'll do that. Okay, so my concern now is that the guardian ad litem was taken off of the case, and the next step of this parenting plan is to go to mediation, not to have the guardian ad litem weasel her way back in. So, and then my other concern is that she also talked to my child without a court order.
Okay, A, the guardian ad litem's in the case until a court says otherwise. B, I'm not the least, Mr. Miller, you really need to listen. I am not the least concerned about the guardian, quote, weaseling her way back in. I need her input. That's why they are appointed. At this point, what we've got is you haven't done what you've been ordered to do, And that needs to happen immediately. Do you understand that?
Yes, and I'll be filing a petition to get a new guardian ad litem.
You are free to file anything you want to file and to note it on. In the meantime, this is over till next week at 9 o'clock. If we don't have that hair follicle in hand by then, there's going to have to be some changes made to the parenting plan. Do you understand that?
Yep.
Do you have any question about that?
Not at all.
Ms. Corey, anything further from you?
Yes, actually. I was relieved of this case because of Mr. Miller's adamant decision not to pay me. He said in court that he was not going to pay me, that he did not pay for things until he received them, and that meant that he wasn't going to pay me. I did actually have the order appointing and submitted that to the school the only time I spoke with his daughter.
Okay. So, Mr. Miller, your approach is to all of this is doing you some pretty significant harm right now. I suggest you look very carefully at what you want to actually get out of this case and make some changes immediately. Is that understood? Your attitude, your approach is endangering your time with your child. Do you understand that?
Oh, I do.
Okay.
I don't feel like the guardian ad litem's looking at both sides equally. She's looking at Taylor's side.
Mr. Miller, did you hear what I said?
I'm understanding what you're saying.
All right. We will be back here next week, the 29th. We will have the hair follicle test in hand. I strongly suggest you change your approach to the guardian ad litem between now and then.
I'm going to file for a new one.
You're free to do that. And whoever the judge is will, I'm sure, look at it. In the meantime, we're going to be listening to Miss Corey carefully and what she has to say. And you need to be aware of that. Miss Young, you had a question?
Yes, two things. Can he get a new guardian ad litem? But I paid Miss Corey in full.
Mm-hmm.
I paid the whole $1,600 for her to be my GAL.
Okay.
Second, there's still a restraining order. I would like that removed so I can speak to my child. I want to ask Cameron if she's been in school. I don't know anything.
Let me stop you. If you've got a motion that you want to make, you need to file that motion, serve Mr. Miller with it, and get it noted on so we can address it. You understand that?
Okay. Is there any way you can drop the restraining order?
If you file a motion, it will be considered.
Okay.
All right. Over to the 29th at 9 o'clock.
Or can I have at least a phone call? They did that last time. If I could at least talk to her on the phone, so she doesn't think I'm just completely gone, because I don't know what he or anyone's been telling her.
It's not like you allowed me to do that when you took her from me.
Mr. Miller, you guys are not going to sit and argue with each other in the middle of this. And Mr. Miller, you also need to sign a release of information to Miss Corey. That's got to be done before the 29th as well. You understands that?
Yep.
All right. 29th at 9 o'clock.
Was that a yes to a phone call, Your Honor?
See you on the 29th, Your Honor.
We will address that on the 29th as well, ma'am.
Okay.
That answers that question. So which one were you looking at? What was the name on it? Because I don't have numbers.
Miller versus Young, number 5 on the docket, 22-30036-908. We've not filed a notice of appearance, but I did see that an adequate cause motion had been filed, but that it was not viewable as of yesterday in Odyssey, for me at least.
Okay. What was the name on that one?
Miller and Young, Cameron Miller and Taylor Young.
Okay, let me see here. This one has a number of documents that also weren't showing.
Present, Your Honor.
Good morning. Yeah, there's a whole batch of documents that are filed here. So, and I was trying to determine on this one, like I said, there's a number of documents that are in the court file that I haven't had a chance to look at because they're not yet viewable.
So the state's involved?
Not at this time. We are just looking at the fact that there was an adequate cause motion filed, and I just wasn't sure if, Your Honor, if that was what was being heard today, because I couldn't view documents.
It looks like that's scheduled for June 26th.
Okay.
What's the adequate cause?
I have no idea, sir. I haven't seen those documents. They've been filed, but they're not. There's a petition to modify, which I think I said I don't have those documents in front of me, so I don't know what that's about. And I was trying to determine what we were doing here today. It was put over from the 22nd.
Cameron's supposed to show a hair follicle test, and that is the modification filed for the 21st. I think I said the 26th. It's a completely different court date.
So I don't see anything filed that was from the hearing on the 22nd. It looks like there was a request. Commissioner Warning had indicated he was setting it over to file some things.
So Cameron's I did get the come with the hair follicle test, and we were supposed to address the situation with Malaya and my contempt in the restraining order.
So, Your Honor, I did get the hair particle test done at LabCorp. I need the guardian ad litem's information so I can sign a release of information to her. So I need her to email me her information so I can call LabCorp and sign a release of information.
Ms. Corey, I think you're involved in this case.
She was out. She said that she would be out of town for this court case.
Actually, I am.
Hi.
I am sort of involved, Your Honor. It's been kind of a rough road. I was actually dismissed last year because Mr. Miller refused to pay me. I've been trying to collect that amount for over a year now.
I need you to email me your information.
Has your email changed? Is it the same one that I have?
Cameron with the K.
So it looks to me like there's a whole bunch of, again, there's a number of papers that have been filed set for, looks like it's June 26th. And
so
again,
I don't even have any of those papers.
And I understand that, sir. They haven't been filed here. We don't have them in the court file yet. I can see that they've been filed at the front counter, but they're not showing up here. I assume those are on their way to you as well. But that'll need to be dealt with. It looks like on the 26th of June, assuming that that's served timely. So at this point, it sounds like there's a number of things that I just had this on for a review, and it was unclear to me why that was on. And then I saw all these file documents. So I guess my thought is maybe we put this over to the 26th. Mr. Miller, you can get your information, take care of your contacts with Ms. Corey. Ms. Corey, you can send him your email. Hopefully we can get that all addressed, and then we'll have the rest of this up in front of us. I was trying to look through the notes from the last hearing. So it sounds like there was a hair follicle. It sounds like that may be done. That needs to be sent to Ms. Corey. There's something about a restraining order in here, which
Yes, there's a restraining order, which I would like you to see if you can revoke, because on the 8th, the paper says that it was only temporary. And the judge moved it over another week because he needed a hair follicle test. He did not provide the hair follicle test. So they kept the restraining order and pushed it over another week. And again, we still don't have the hair follicle test. And I would love if you could take that away so I can speak and see my child, because now I've done everything I'm supposed to do, and Cameron has continued to not do what he's supposed to do, and I still am not able to see my child. I filed all the paperwork. He was served. I can talk about it now. And now it's going on almost a month of me not seeing my child again. I don't even know if she's in school. I keep getting messages saying that she has absences. So I don't know if she hasn't been in school the last almost 3 weeks or what's going on. I have no idea what is going on.
Can I say something, Your Honor?
Well, I'm trying to find that order. It looks like there was an immediate order that was entered April 11th, which would have been good through 5/8.
It was supposed to expire on the 8th, but they kept pushing it because he didn't come with his hair follicle.
You sure it was in this file? Yeah. Well, like I said, when I looked through this, I couldn't find that order because on the 8th of May, it looks like the notes indicate that the restraining order would remain, but there's no order extending.
Because on my paperwork, it says it would have expired on the 8th unless they extended it. So if that's happening, is there any way for you to take it away now, since it was technically supposed to be expired on the 8th, so I can talk and see my child? Because now I go from having her, Cameron being in jail, to me not even being able to speak to her. And there's no reason why I should not be able to speak or see my child. Especially that this is the
Your Honor.
that Cameron has.
Okay, hold on, ma'am. Just say, what's your position on that, Mr. Miller, about her being able to speak with the child?
If you allow her, I would like it to be supervised because I've had Malaya for 5 years, and then I got incarcerated, took care of my warrants, and then that's where Lewis County told Taylor that she could have Malaya on her weekends and our parenting plan still stays into effect. But Miss Young did not follow the parenting plan. She decided to keep her. She decided to hide her. She took Malaya out of her school for weeks because I was on the hunt to get my kid and to serve her.
Your Honor.
Can I finish, please?
One at a time, please.
And then so once I did find her, I had Thurston County looking for her. I had Centralia Police. I had Lewis County Sheriffs, Pierce County Sheriffs looking for her. And Taylor took Malaya from the house that they were sleeping at. They took her down south to Centralia, to Thurston County, back up to Pierce County. Malaya's been with me primarily the whole time except for 3 months. Now, with that, my daughter does tell me stories about how her Mima, which would be Taylor's mother, would tell Malaya to hide, get down low in the car, because your dad's around here somewhere in the same area that I live. And so when I found her, Malaya starts telling me all of these crazy stories. So if you allow Taylor to see Malaya or to talk to her, I would like them to be supervised, please.
Your Honor.
Well, hold on just a second. What I've got is, again, this case is kind of a mess because there's it looks like the parenting plan that I'm looking at is from September of 23. Okay.
Correct.
He is the primary parent, so he has essentially custody in the case. There was an order, a restraining order entered, which would have prohibited your contact, and that happened back in April of this year. That order would have expired on the 8th. It appears that Judge Evans extended that, but there was no order entered doing that. So at this point, there's no, I guess here, and that now we have a whole bunch of new documents filed. It looks like maybe for, again, I don't know what those are all about. It's obviously some sort of modification of the parenting plan. And whether or not that'll be addressed or not will depend upon whether there's adequate cause. Again, that's not in front of me today. That'll be heard on the 26th. It would make sense to me at this point, with what little I know, which is not a lot, and Ms. Corey's getting back involved, it sounds like maybe at some point or not.
I really would not like to continue on this case. Mr. Miller expressed vehemently during the last hearing that he did not want me on the case. But if he does get appointed a guardian ad litem, I would suggest that he be required to pay up front.
Okay. Well, here's my thought on this. Right now, Mr. Miller, you're the primary parent, correct?
Correct.
And there's a child with you, or
yes, sir.
Okay.
I do want to state that she is in school too.
Okay. So
and he switched her into school without my consent, which that's contempt in our parenting plan.
Okay, so it looks like there's a lot of things happening in this case. It's going to be back in front of the court on the 26th. In the meantime, what I'm going to do here, give me just a second, because I don't want us to get into a situation where there's nothing.
Your Honor, may I say something?
Sure.
I don't believe there should be supervised visits. Before this, we had a parenting plan and things have changed significantly. He was in jail for multiple charges that were unsettling to me. And he got a restraining order on me for my child. I went from having her to not having her at all. And now this person has her, won't let me see her, speak to her, nothing. And he's not worrying about the mental well-being of my child because she didn't want to go with him in the first place. And me not being able to see or speak to her just because he feels a type of way is not right. They should be supervised because right before that, when he made his decisions of domestic violence and his obstructing law enforcement,
hold on
he was
a second.
not thinking of our child.
Okay, I don't have all of this in front of me, and
I filed those like a month ago at this point. And every time they say, the first court date it was, he didn't have his paperwork. The next one, he didn't have his hair follicle test. No one's looking at my paperwork because if they did look at the paperwork, they would know that everything Cameron's saying is a lie. I've put proven facts and evidence that he is lying under perjury and under oath. And no one is
not actually.
Okay, hold on, both of you. I have a declaration that you filed May 3rd, which responds to the temporary order. And I don't know if Judge Evans looked at that on the 8th or not. There was a discussion about not a bunch of documents not being served. I have no idea what those are because it's not clear to me from the court record what was filed. There is a new matter that may move forward depending upon adequate cause. Currently, your parenting plan that was entered last fall is the parenting plan that's from September of 23. That's the parenting plan that's in place currently. And he has primary residential care of the child. There was that immediate order that was entered. She's responded to that at some level. Again, it looks, there's a lot of notes in here, but there's no paperwork as to what I don't know. It's Mr. Miller, did you receive that declaration from May 3rd?
Which one?
She filed a declaration. It says it's 26 pages long. It's handwritten. It's mainly includes some Lewis County guardianship documents, or at least a denied order.
Yeah, I got all that.
That was for when he was in jail and I had her because he went to file for contempt, which this is what this hearing's about. But how can I be in contempt if he's been incarcerated for 4 months and a court order gave her to me? There was no way I could talk to him or anything.
Okay, so here's what I'm going to do. The parenting plan that's from September is the current parenting plan.
Unless we could stick with the parenting plan until the court date of the 26th. That's why I at least have her for the weekends.
So at this point, there's no order modifying the parenting plan. So the parenting plan that's currently in effect is the parenting plan before the court. When I look at what Mr. Miller filed, it was an immediate restraining order, but there would need to be some sort of modification of the parenting plan case filed. And that's, at least I don't have anything in this file. There is, as I indicated, it looks like, and I assume this is, mother has filed a new petition to modify that's not been served. It's not in the court.
Yeah,
file.
I just did that. Yeah.
Okay, it's not before the court at this point. So at this juncture, your parenting plan from September of last year is the parenting plan that you need to follow. Okay. So whatever the terms of that are is what you both need to follow until somebody files and the court hears something that changes that order.
So can you take the restraining order away?
Well, just listen, okay.
Your Honor.
Sir, I just need to have you listen for a second. Okay, you've not filed something to change that parenting plan. You filed an immediate restraining order, but that doesn't change the parenting plan.
Yeah, I understand that.
I'm talking to him right now. So your parenting plan from September is the parenting plan that's in effect. She's now filed some documents. I'm not looking at those because I don't have those. You don't have those. I'm assuming asking to change the parenting plan. You'll get those. You can either respond to that or you can file something to change the parenting plan from last September. Because that's the parenting plan you've got, and nobody has got anything that's properly before the court to make a change to that plan, to modify it. So that's the parenting plan you need to follow. And what I'm signing an order here today is you need to follow that plan. The restraining order that was in place, it looks like it expired on the 8th. And I don't know, Judge Evans may have extended it verbally, but he did not. From what I can see here, that was not re-extended on the 22nd. So.
Okay, so can we do supervised visitations? Because if she doesn't,
Sir,
no.
Sir, you need to file
Taylor,
something.
stop talking, please.
But you both need to just listen, okay?
Nobody
has got any, sir, nobody has filed anything to change the terms of the parenting plan, which was what it would take for me to impose supervised visits. And again, Ms. Young, if you have the visits that are set on the plan and you don't return the child as ordered, then you're looking at likely some potentially even criminal charges. So you need to make sure that you both follow the parenting plan until we get a proper legal paperwork that gets it back in front of myself or another judge to make a change to that parenting plan.
Yes, Your Honor.
And that means if she's got visits that are set out, those need to be followed. And if you've got the visits, the child needs to be returned at the end of them.
Yes.
So that's the order I'm signing right now. And then when we, you'll get, again, it looks like you got a bunch of paperwork that's on the way, sir. We're back on the 26th. If that's been properly served and it's timely, we'll address that. You can file something yourself if you want to make a change, but at this point, your parenting plan from September of 2023 is the parenting plan you both need to follow. So that'll be my order I'm signing today, clerk. And as far as everything else, I really it seems to me that we need to probably come back on the 26th, see if there's grounds to make a change. But there may or may not be. I don't know that. I haven't got all that information, either side, either what she's saying or what your response to that'll be. But in the meantime,
is involved.
I'm sorry?
But the state's involved?
If the state's involved, it would be at the level of child support. If there is either a change of primary residence or some other reason to change support. And then, again, that's not in front of me today. I'm not changing the parenting plan that's currently in place. So the parenting plan
will do in exchange on Friday.
I'm talking about for the 26th, because wasn't that first lady representing the state?
Your Honor, I can clarify that. We would only need to be involved if adequate cause is granted at that hearing. And as we're not just discussing that today, we don't know what that decision is. The state is not involved at this time, but we would be involved regarding child support only if adequate cause is found to change the parenting plan, as that may change what child support currently looks like.
Okay, thank you.
And I have no idea whether whichever judge hears this on the 29th will make a finding of adequate cause. I don't know that because I don't have that paperwork in front of me. And obviously you have a chance to respond to that before that's found.
Yes, Your Honor.
All right,
So
so
where
at
do
this
you
time,
want to?
your current parenting plan, which is the one from September of last year, is the one you both need to follow.
Okay, and since he no longer lives in Longview, is there another exchange point we can do on Friday?
No, I'll meet you at Gigi's truck stop.
Your parenting plan is currently in place is what you both need to follow.
Okay.
So I'll meet you at Gigi's truck stop.
Okay, at 6 o'clock.
All right. So that's all
Never
for today.
show up.
So that is all for today. I've signed that order requiring you both to follow that parenting plan.
Thank you, Your Honor.
Thank you.
Okay, you're welcome.
Next, I have Cameron Miller and Taylor Young. Cause number is 223-369-08. I'll ask if Cameron Miller is on the line.
Right here, Your Honor.
Okay, welcome, Mr. Miller. And is Taylor Young on the line?
Yes, I'm here.
Okay, welcome to both of you. And I see that, let's see, one moment. See that Ms. Corey is on the line with us also. Welcome to you. We're on today for Ms. Young's motion for adequate cause to modify a parenting plan. And let me just double check as far as service. I had a question, Ms. Young.
Yeah.
So let me just see who's speaking. Ms. Rhodes, Megan Rhodes.
Yes, sorry.
Please mute?
Yes, give me just one moment.
I'll take care of it. Thanks. Okay. Yes.
So I need to go down to the courthouse and I need to the court called me, I think about a week ago, and I need to switch. I need to put my name as the petitioner and hers as like the respondent or something like that. And I still need to serve Miss Young. And then Miss Talia, if that's correct, I tried emailing you and contacting you to set payment up. And then, yeah, it's in an email somewhere. And then I also left you four voicemails. And then my hair particle coming from, who is that? LabCorp. They should have already emailed that to you too. Out of Tumwater. Okay. Go ahead.
I've not received an email from you. I've not received an email from them.
Okay. I'll check up on that then.
I haven't received anything either.
I know I still need to serve you and I need to go back down to the courthouse to switch paperwork around, they said.
Okay. So let me just kind of step in a bit. We're here on Ms. Young's motion for adequate cause to modify the parenting plan. I wanted to first check with Ms. Young as far as service. Did you serve a copy of the summons and the petition to modify on Mr. Miller or to Mr.
Yes, and he threw them in my stepmom's face.
Could you say that again?
He threw them in my stepmom's face and never responded.
Okay. And did you file an affidavit or declaration of service that the documents were served?
So none of that is true.
So hold on, Mr. Miller. So Ms. Young, what I'm looking at on June 3rd, I see an affidavit or a declaration of proof of personal service. Says Angelia Barton served Mr. Miller on May 31st, 2 documents, a proposed parenting plan and a motion for adequate cause.
Yes.
What I don't see on that is that there was no service of the summons and the petition, which are necessary to move forward with any type of motion. So
I filled everything in with it and the proof of service.
So on the proof of service, it indicates that it says Mr. Miller threw the papers across the parking lot, but there's only 2 documents that are shown that were served upon him, the proposed parenting plan and the motion for adequate cause. So the boxes that the petition and the summons, those are not marked. And so when I read that, that tells me that he didn't get all the documents. So procedurally, we can't move forward today because he hasn't been properly served with those documents. And that's probably pretty frustrating for you because you go through a lot of effort to get things done. But at this point, we're not in a position to move forward with your motion for adequate cause and to modify the parenting plan.
Even if it's also been 3 weeks, more than multiple times, he hasn't responded with his hair follicle or anything.
Okay.
They keep pushing it and pushing it. There has to be some kind of consequence for him not doing what he's supposed to do.
So going back to the hair follicle, can you remind me the date that was ordered?
Corey ordered it.
And Corey, you may be able to know also.
Your Honor, the hair follicle is done. If LabCorp hasn't sent that over, I can't control that. All I can do is call them and have it sent it over. That's it, but it's done.
So when did you take the hair follicle?
3 weeks ago.
What date? What date did you take the hair follicle?
I'm looking. It would have been the 4th or the 5th.
Of June? Okay. Ms. Corey?
It was ordered on May 22nd by Judge Warning.
Okay, so it was an oral order.
I believe so.
Okay, so let's see.
Under the 522 motion hearing.
Okay, so on May 22nd indicates the clerk's minutes say the court sets the matter over to May 29th at 9 a.m. The hair follicle test to be provided by then. So on May 29th, we had a hearing, and that was in front of Judge Brasher. There's a discussion about the hair follicle test. Mr. Miller requesting the GAL to email her information so he can submit an ROI. GAL to provide information to Mr. Miller. Hair follicle test needs to be sent to the GAL. So this was discussed previously, from Mr. Miller. Did you send a copy as instructed and discussed by the court on May 29th?
I gave provider all of the information for them to do it.
Did you send a copy to all the parties? That's kind of the key part. We don't care what the others are doing. The onus and responsibility is on you.
Correct. No, I didn't.
Why not?
Because I thought that they were going to reach out and send it to her.
So when the clerk minutes say that Mr. Miller needs to send the hair follicle test to the GAL, what part of that do you not understand?
I thought I was supposed to give them her information and sign a release of information for her.
That was part of the discussion. Yeah.
Yeah, so then that's where I got messed up then.
So, Mr. Miller, are you in a position today to get a copy of the hair follicle results and email and also mail to Ms. Corey and to Ms. Young?
Yeah.
Okay, that's a court order that you'll accomplish that today. I'll do a bench order so there's no confusion. One moment.
Are you able to email it to me?
I have emailed it to you. Most recent email was May 29th.
Okay, I'll look for it.
Okay, so Mr. Miller, just so you're aware with the order that I'm writing or just wrote, it says Mr. Miller shall forward a copy of the hair follicle test taken on or about June 4th or June 5th, 2024 to Ms. Young and to the GAL by close of business today. Any questions on that order?
As of close to business today?
You have to do it today. You have to send it today. It has to be completed by the end of today.
Okay, so I'm at work right now.
Would tomorrow be easier, better?
Yeah,
okay.
Please.
So I'll amend that so it'll read June 27th. Okay, so that takes care of the hair follicle issue, Ms. Corey. Did you, or was that Ms. Young that spoke?
Oh, it's me. I was like, so do I need to go serve him another summons for the modification, or can you put, since he's here now, can we discuss a date for the summons to where, or do I need to reserve him again?
Yeah, so the issue with service of all the documents for the adequate cause motion and the parenting plan modification, Sometimes it's service is uncertain when and where that'll occur. So generally we don't set a date in the future. We wait for the service to occur. And then when you're doing the service, then you'd set a docket notice and setting it to a particular date. So I'll leave that in your hands to make a determination of what date that should be. And then then the documents can be served upon Mr. Miller.
Yeah, that's what we did when I did. I'm the one who set the 26th and the 12th for him to respond by the 12th. I did all that. That's why I didn't know that the papers weren't turned in, because I picked the date and everything.
Right, like I said before, there's 2 documents that were absent in the documents served upon Mr. Miller. So all those same documents he served before, and then the addition of the petition and the summons also have to be served upon him, and then give the date for the future. Okay.
Your Honor.
Yes.
With all the difficulties she's had with serving him, is it possible that she can serve him by mail? I believe that was approved.
Yeah, I don't think that, so the prior service was in person, and there's Mr. I believe.
He served me by mail the first time. He just dropped it off at my mom's house, and they used that.
I'm just looking for a pleading filed by Mr. Miller so we know his address.
It's there.
Okay, I've got a Rochester address. Mr. Miller, is that the correct address?
Yes, Your Honor.
Okay, and it looks like it's on is it like 18th Street or something?
Yeah.
Yep, okay. Yeah, so Ms. Young, that's fine if you want to serve via mail, so you can mail that to that particular address. And then Mr. Miller will be on the lookout for those documents so you can get them, and then you can respond in writing to, so I know what your position is.
Am I also able to mail her or email her for my response?
Yep, that's fine. And you'll see that with the pleadings that she's filed, and it's looks like it's a Centralia address.
Yeah.
Okay. Other items to address today, Ms. Corey? Okay. I didn't hear you, but I read your lips and it said nope. It looks like you're unmuted, so I'm not sure what happened. And then Miss Young, any other items on your end?
So there's no other court date. It's just when I make a new court date.
Correct. And then Mr. Miller, any further items on your end?
No.
Okay. I appreciate you getting
and one more thing.
Test forwarded to Miss Corey and to Miss Young.
One more thing.
Yes.
And on the pickup and drop off, we're not in Cowlitz anymore. Can we move the drop off and pick up somewhere up here? He lives in Rochester and I'm in Centralia. We're driving 45 minutes away just to turn around and come back.
I would rather not.
So anytime issues with, there's a request to change a parenting plan or a provision of a parenting plan, there needs to be some type of written motion with notice to the other side. And so if, I'd encourage you at this point to see if you can talk about it and come to an agreement. If you can't, then there could be a motion and that could be addressed in the motion to modify the parenting plan also. So sorry, I can't help you on that one today. There just has to be that notice and opportunity to respond. Okay. All right. That'll conclude the hearing for today. Thank you. Next, I have Cameron Miller and Taylor Young, 22-3-36908. I'll ask if Cameron Miller is present. And Mr. Jensen, I'm going to call you a case after this one. Perfect. Thanks. All right. Hi, are you Taylor Young? Okay. Welcome, Ms. Young. And I'll ask if Cameron Miller is on the line. Cameron Miller. All right, Mr. Miller, if you are speaking, I cannot hear you, so make sure that you're unmuted and state your name. I'm going to take a look at the participant list. I'm not hearing anybody speaking, so I'm just going to look under his name. Not seeing anybody in the K's, and I'm looking in the M's, not seeing anybody there either. He's in jail. He's incarcerated. When was he arrested? On Friday. Okay. And then it looks like you received notice of today's hearing.
Yes, I got a cop. I was served with a restraining order, but not contempt, but the restraining order had the same day. Okay. But I didn't get a chance to file this. I had court as well, and I had a protection order And he didn't go to court then either, so they granted it to me for a year because right now we're in a case of sexual abuse.
So you have an existing order that restrains him from contacting you, is that correct?
Yes, for your and my child.
Okay, all right.
And I have it right here too. It was just finalized on.
Okay, all right, thanks. And then the, and are you up in Centralia? Is that where your home is? Okay. And then you said you were served on Friday, right? So just. So I'm curious about you're here today.
Oh, I was served by Officer Croy. I don't remember exactly what day it was. And then I served him and he didn't get served until he was put in jail because he was avoiding it.
So your general time frame when you were served is what? When we were served, roughly? Week and a half ago. Okay. All right.
I also didn't know how that worked with him having a restraining order, but I already had a protection order, and it protected Malaya from him.
Yeah, sometimes there's competing protection orders, and both parties can be restrained, in different types of cases. So that's not unheard of. So he's not present. You've indicated that he's incarcerated still, and he's in Cowlitz County. Is that correct?
He's in Thurston.
He's in Thurston. Okay. Madam Clerk, do you know if there's been any requests from Mr. Miller to appear via Zoom? Okay. I'm going to double check in my email to see if he had made a request of maybe my assistant or what have you to appear via Zoom. Okay, I haven't received any notice that he had made that request. So let me just take a quick look at his motion again, just one moment. Okay, I think what I'll do, he's not present today, so I'll deny the restraining order, and it can be brought back again once he's present if he wants to. But at this point, I'm going to deny it. So I think I was given a proposed order. So let me just see if it's here, and we'll just indicate that it's denied. Madam Clerk, just confirming with you, Mr. Miller prepared a proposed order, but I'm denying it. Is there a separate denial order that I should sign, or just simply put an X through it all and say denied? Okay, I'll do that.
Your Honor, so aside from the parenting plan, if this shows that I have full rights to her on this paperwork, does that override, since it now has jurisdiction over the parenting plan, or is that the last time if he gets out, he's still able to just take it? Because
as a general rule, and this doesn't hold true always, but as a general rule, when there's restraining orders that are in place that are, say, just a general civil restraining order, generally those will give way to a family law order. So generally the idea is that if the family court makes a parenting plan order, then that would control and would control over the restraining order. There still may be those restraint provisions that those are still there, but the court can generally enter in and carve out a parenting plan that the parties would need to abide by.
So could we do since he is incarcerated and he isn't getting out anytime soon, can we make it to where I do have custody for her at this moment?
Not without notice to him.
He has notice from this, he got served in jail too.
Do we have a hearing set for today for him that you gave notice of?
No, he's in jail. The sheriffs and stuff are serving him there.
Right. So the idea is that there needs to be due process for both parties. So if you're asking for new relief or asking for something new and he doesn't know about it, it would be improper for me to grant that here today because he doesn't know anything about it.
But he knows about it. It says it in the protection order.
Yeah, you said the protection order has been entered, so that order's valid. But you're asking me to take an additional step. It sounds like, is that true or not? Not true.
Yes, about the parenting.
Right. And did you give him notice that you wanted to talk about that today?
No, I wasn't able to.
Right. So that's why we won't talk about it today, because that's the due process. Each party has to have notice and an opportunity to be heard. So he hasn't been given any notice about what your request is, hasn't been given an opportunity to be heard on the issue. So I'm denying that request. Do you have any questions?
So do I just go file a change of parenting plan and come out here?
That's an option. If you'd like to do that, you'd have to give him notice and he'd have an opportunity to respond and have an opportunity to participate in the hearing. So if you want to do that, that's fine. You could do that too.
Okay, but I'm not in contempt, correct?
There was no motion for contempt here today. There was a request by Mr. Miller for a restraint order to be imposed. He's not present, and so I denied his request.
Okay, thank you. The clerk just said it was for contempt.
Okay, thank you.